I want you guys to tell me in a private chat. Don't give the answer away to everybody. I want you guys to tell me in a private chat. You can tell me in 2 words. There's your hint. What duties do I owe my client? What do am I that predictable? What duties do I owe my client? So it looks like the duties that we owe our client is OCAR. The client gets OCAR. Remember, the client is the one that's flying in first class, right? The client is the one that gets the A treatment. Some of you mentioned honesty and fairness. That's what I owe my customer. So my customer still gets duties from me, right? They still get things from me. Basically, I can't lie to the customer. I can't be dishonest. I can't be unfair with the customer. The client is the one that gets first class service. They are the ones that get OCAR. How do they get OCAR? Because they enter into an agency agreement with me. We purposely enter into a relationship. And that agency agreement, they're hiring me to do a job. So when we get into Unit 8, we're going to look specifically at our agency agreements. So some of you said, if my client gets OCAR, my customer gets honesty and fairness, everybody gets the disclosure of material facts. I never have a reason not to disclose material facts. So it does not matter who you are, client or customer, everybody gets the disclosure of material facts. We talked about material facts last week. Specifically, we talked about facts that are about the property itself. So maybe the roof leaks, maybe there's structural issues, maybe there's termite damage or damage from termites. We said material facts were facts relating to the property, maybe a proposed zoning amendment on the table, maybe an NCDOT road project. It's not about the property itself, but it's close by. It could affect the property. We talk about material facts, any facts that relates to the ability of our principal to complete the transaction. If you find out that for whatever reason your client can't finish the transaction, that's a material fact that we have here. If you find out we're under contract and your buyer doesn't get loan approval, or you find out your seller is now facing bankruptcy or foreclosure, that would be a material fact. And then the last material fact that we specifically addressed, any fact known to be of specific importance to our principal. With that, I always have my very simple philosophy. If it's important to my buyer, then it's important to me. If it's important to my seller, then it's important to me. So once they share with me, Julie, I have to sell for X amount. Julie, when I buy, I have to have this feature. I now have a material fact on my hand. Okay. Then we talked about what I call the big 4: willful misrepresentation, negligent misrepresentation, willful omission, and negligent omission. The big 4 revolve around material facts. What happens if you mishandle a material fact? You either lie about it, which is a misrepresentation, or you omit it. You didn't put that information out there. So you either open your mouth and a lie fell out, or you kept your mouth shut. And then to dig a little deeper, the commission's going to want to know if you did it on purpose or was it done on accident. If it was willful, it was intentional. If it was negligent, it was on accident. So the very last thing that we talked about, I think was the big 4. Yeah. So the last thing we talked about was the big 4. One thing we didn't get to talk about last week, we talked all sorts of things about things that were material facts, One thing we didn't get to talk about yet are things that are not considered material facts in North Carolina. And in North Carolina, the haunted house on the block, the haunted house in the neighborhood, stigmatized properties, these are not material facts. Stigmatized properties are those that have been branded by society as undesirable. Maybe they're the site of a death or an illness or a serious criminal conviction, murder, suicide. Mark my words, as sure as I stand here in front of you, at some point in your real estate career, when you're showing property, a buyer will ask you, did anybody ever die in this house? Mark my words, you will get that question. You can choose how you answer that. You can say, that's not a material fact in North Carolina. I don't have to answer that. I would soften that up just a bit, but you don't have to answer it. If you do answer it, if you do choose to answer it, you need to be honest. You can't lie. Be very careful. Let's just say, for example, you're selling a house that, or you're showing a property, you're selling a property that's 80 years old. And let's go further and say, you know, the current family, you know, the current owners personally. You may be able to say nobody from the current family died, but do you know the history of the house? Do you know the people that own the house before them and before them, going back 80 years? You guys see what I'm saying? So even if you know the current owner and you say, no, nobody ever died, you're making a statement about something that you may not know about previous owners. Does that make sense to everybody? So sometimes your honest answer might be, I don't know. I don't have a duty to disclose this. I don't have a duty to discover this. There is one exception to this rule. If you're ever asked if somebody ever lived in the home that has AIDS or HIV, your answer is always, federal fair housing prohibits me from answering that. Because those with AIDS or HIV are protected under the handicap disability class of fair housing. We're going to talk all about fair housing in Unit 19, so we'll see this again, actually. If you're ever asked, did anybody die, anybody ever live in this home that have AIDS or HIV? Your answer is always, I don't care if you know or not, your answer is always, federal fair housing prohibits me from answering that. Some crimes, some deaths are more publicized than others. So, you know, if it's been splattered all over the national news, you may find it in your best interest to disclose that. Sometimes neighbors talk. Nothing makes me more nervous when I'm showing a property and here comes the neighbor. Yoo-hoo, how are you guys doing today? I'm like, oh crap, what are they gonna say? That makes me a little panicky when the neighbor comes over. But guys, people talk. So sometimes it's best to disclose if you know, because the neighbors will tell them. But it's up to you, and every scenario is different. And again, maybe your genuine answer is, I don't know. I think it's also important that in some states, this is a material fact, in some states it's not. Now, I don't know what states are or not. I can only tell you about North Carolina. But if you're ever working with buyers from other states, they may come in thinking that that's a material fact. You guys with me? So part of what we're doing is help to educate our consumers. I appreciate what state you're from. It's a material fact and it has to be disclosed there. But here in North Carolina, it is not. Another thing that is not a material fact is the presence of convicted sex offenders nearby. When it comes to this, I'm a huge fan of being the source of the source. So when my buyers or tenants ask, usually they have families, they have children, when I'm asked this, and if I'm ever asked this, I'm choosing to send them to the North Carolina Sex Offender Registry. Let them do their research and investigations. They need to be aware of a couple things. First off, this word says convicted, right? Unfortunately, not all sex offenders are caught, are they? So I would be careful about making a statement that there are no sex offenders, because you only know about convicted on the registry website. The other thing I would caution buyers that ask, there may not be a convicted sex offender that lives next door today, but that doesn't mean one can't move in tomorrow. So just make sure that's a big reason why we can't make that statement. So be the source of the source, have them investigate. Bottom line, let's all know where our kids are and who they're with, right? Especially in a new neighborhood. So stigmatized properties in North Carolina are not a material fact. Presence of convicted sex offenders, not a material fact. I still can't lie about it. I never have a ticket to lie, but I do not have to disclose. Megan's Law. Megan was a young lady that was a victim of a sex offender, a young girl. And now we have Megan's Law. Megan's Law requires convicted sex offenders to register. I don't know how often that registry updates, though. I don't know what their time frame is. Like if they move, how long do they have to notify that? But Megan's Law would dictate the registration. So when it comes to material facts, we always have a duty to discover and disclose material facts to everybody. I don't care who they are. Are they my customer? Are they my client? Are they just a consumer that I haven't even had a chance to form a relationship with yet? I always disclose material facts. Lots of brokers use disclaimers. I'm not saying that's right or wrong, but a disclaimer isn't going to avoid your responsibility. Sometimes in a listing, for example, you might see buyer to verify. That's not an out for the listing agent to not disclose. And we always need to be on the lookout for those red flags, things that pique our interest, that make us want to ask more questions. I think red flags come up more often. I mean, they come up with sellers too, but I think mostly with buyers is where we really need to be on the lookout for red flags. Guys, when a buyer's looking at a house for a first time, second time, they're going through with rose-colored glasses, and they're going through the house thinking about how their family can live in this home, how their family can utilize this home. They're thinking, can I see us doing homework here in the evenings? Can I see us doing Sunday brunch here? Right? They're looking at the family dynamics. You and I need to help them out by looking at the ceiling, looking at the walls, looking at the floors, looking at the details that they're not seeing because they're taking in the big picture. I had a buyer once. We were in a house. We were through the whole house. This was my eye-opening experience. We were through the whole house, and we were about finished. We were in the kitchen. She was standing back, taking in a few more things in the kitchen. And I made some random comment about the sellers must have a big dog. And she said, "Why would you say that?" And that blew my mind. Every single baseboard in that house had been gnawed on, chewed on, scratched up, every single one. She didn't see it because she was looking at the big picture. She was looking at that kitchen like, can I see me preparing meals here for my family, right? She'd only been in that house once. She was looking at the teeny tiny details. And that's why I think it's important that you and I help them be their eyes for things that they're not seeing, those red flags. And when you see red flags, that should be an indication to us to ask questions, investigate further, find out more information. Starting on page 147, and you guys can follow along, there's some additional duties. Now we're going to talk more about these later, so we're going to go through them pretty quickly right now, understanding that we'll see them further discussion when we get into our license law and commission rule. Additional duties that I owe parties: I cannot make false promises. I cannot make false promises. If you promise somebody you're going to do something, do it. If you promise somebody you're going to follow up and get more information, then do it. And that does include communicating with other agents or your advertising. We cannot make false promises. We always have to avoid conflicts of interest. Now we're getting ready to talk about dual agency. So again, this is why we're going through these pretty quickly, because we'll see this all again. Dual agency is a conflict of interest. Excuse me, undisclosed dual agency is a conflict of interest. Another conflict of interest is self-dealing. Remember what Old Car says. Part of Old Car says, I put my client's interest above all others, including my own. So if I'm acting for myself and not in the better part of my client, that is considered a conflict of interest. And then another conflict could be representing another broker without consent. Once you get licensed, once you get further in your career, you may have the opportunity to become dual affiliated, which means you can hold your real estate license in two different firms, two different places. And that's okay, as long as you have consent of both of your firms, as long as both firms give you permission. Just a couple examples of conflict of interest. Again, we'll see these again. We need to properly account for funds held in a trust account, also known as an escrow account. Trust account is one of the last things we talk about in this class. So we will talk about trust accounts, escrow accounts. We have to act competently. We're going to start this week looking at some of our forms, for example, our agency agreements. When we get into Unit 10, we're going to look at our offer to purchase and contract. I have a duty to make sure that I'm filling these out competently. When in doubt, find out. It's pretty simple. If you don't know what goes in a blank, do some research, ask some questions, find out. We have a duty to avoid improper conduct. You have to act worthy. You have to act proper during the transaction. We have a duty to deliver instruments within 3 days. First off, let's talk about what the heck an instrument is. An instrument is just any document related to this transaction. So it starts at the beginning of the transaction with our agency agreements, forming that relationship. Halfway through, we have our contract paperwork. And then at the very end, we have closing documents, closing paperwork, and anything else that might fall in between. I think a general rule of thumb, if they sign it, they deserve a copy of it. Wouldn't that just be a good practice? They sign it, they deserve a copy of it. And what the rule says is we have 3 days to deliver within execution, within these documents being signed. So your seller signs an agency agreement, you send them an email and say, here's our signed agency agreement. I look forward to working with you. Have a nice day. I now have a sent email documenting that I sent it. Because what do we document? Everything. Guys, it really shouldn't take 3 whole days to send an email with a PDF attachment saying, here you go, right? 3 days is the max. How long does this take? And please note this word says delivery. What they do with it when they get it, not on me. is it? Do they want to print it out? Do they want to store it? Do they want to delete it? My job is to deliver it. The exception to this rule is when we're delivering offers to our sellers. And when I have an offer to deliver to my seller, I have a duty to deliver that immediately, but in no event later than 3 days. This could be a listing agent working with a seller. This could be a buyer's agent working with a for sale by owner. Anytime you're delivering an offer to a seller, we do so immediately. And then my principal deserves to know, we're going to talk about commission. We will talk all about your money in Unit 8. We're going to hash out our commission and our agency agreements. But what if I'm going to make a bonus? What if, for example, the builder is offering the buyer's agent a bonus? Don't you think the buyer deserves to know that I make more money? I could make a bonus. I could make more money off this transaction. The real estate commission does. So if we're going to make anything above and beyond the stated commission, bonuses, referral fees, kickbacks, we'll talk again more about these. And there's certain rules on what kind of referral fees and kickbacks we can, if any, accept. So we'll see this as this class continues. I also want to point out in your book on page 147, the in practice. And I point this out because I get asked this a lot. Once you affiliate with your firm, you're more than likely going to be offered or provided errors and omissions insurance. E&O insurance is like our medical malpractice insurance. So they may protect you. Your E&O may cover you if you get yourself in trouble. We'll talk about your trouble in just a second. If it's a willful thing, if it's something that you do on purpose, intentionally, I'm not sure that E&O is going to cover you. But again, your firm, most firms have a policy that will cover you in the event something unexpected, unintentional happens. I'm a big fan of the in practices in your book. If you guys aren't looking at those yet, please do, because there's your real world. I know you guys are so anxious to get out in the real world. Remember your goals, though. Before you get out and sell a house, you got to have a license. Yes? All right. In practice, for example. So what happens if you breach any of your agency duties? What happens? Well, all sorts of things could happen. You could face disciplinary action by the Real Estate Commission. The Real Estate Commission is a governing body that regulates our license. You guys remember what the main purpose of the Real Estate Commission is? Is it to make sure that I make lots and lots of money? No. Does it help me to have lots and lots of sales? No. The Real Estate Commission's main purpose, that's right, is to protect the public. And if you harm their public, you could face disciplinary action. How do you harm their public? You breach your agent duties. You violate license law and commission rule. The Real Estate Commission is not going to fine you. They're not going to impose a fine on you. Unless you're a timeshare developer. Remember, that's our one exception. The only time the Real Estate Commission will get involved with matters of money is if you're a timeshare developer. So what does the Real Estate Commission do? They could take your license. They could suspend your license. Maybe you get a slap on the wrist. Maybe you're lucky and you get a slap on the wrist. But understand, they could also suspend your license. They could revoke your license. Bottom line, it comes down to how badly did you harm their public? And while the Real Estate Commission can't fine you, the courts can. So the party that you injured could hire an attorney and sue you. You could be looking at civil actions. You could be looking at criminal prosecution. And you could be looking at civil liability. If your actions caused your principal to misbehave, even though your principal is the one getting in trouble, it could come back on you as well. It's so important that we understand the current laws, the current rules. Guys, this is why you're here. This is why you're in this class. I always feel like my job is twofold. Part one, get you the information you need to get you through the tests. The second part of my job is to help keep you out of trouble once you do have your license. Help drive you towards the license law and the commission role. I'm going to go off PowerPoint just for 1 second. I would like to take just a second and introduce you guys to the North Carolina Real Estate Commission's website. It's ncrec.gov, or you can just Google North Carolina Real Estate Commission and it'll come up. This is a public site. There's all sorts of good information on here. Now, I wouldn't mind you guys poking around. I don't want you spending all your study time here though. But there's some good stuff under publications, really good stuff under resources. And most of this stuff is available to the public because the commission wants to make sure they're not only helping to educate you and I when we get our license, but they're also to help educate the public. So resources is a great tab. If you come down the homepage, one thing the commission do is every month they send out an e-bulletin. You'll get an email once a month about the first of the month. April's hasn't posted here yet, but it is out. So you'll get an email with an e-bulletin. This is good information for me and you because it helps the commission get the same message across to all of us. So you'll get this email with the e-bulletin. Again, good articles. You can meet your commissioners here. Various things. And one thing of note, there's a link in every single e-bulletin that says disciplinary actions. And when you click on that link, they're telling everybody in the world, when you mess up with the commission, who you are, where you're from, what happened to you, and what you did. So in addition to having your license suspended or revoked, they plaster it all over their website. They put it in their bulletin. Isn't that something? I think it's keeping you guys out of the e-bulletin. That's more of an incentive to have you guys do good than it is having your license disciplined. Yes, I have seen people name in here I've known. It happens. I'm not saying they're bad people. They did something they shouldn't have and they got caught. So again, and we're not gonna, I tell you guys what I'm seeing a lot lately. The disciplinary actions that I'm seeing a lot lately are mishandling material facts. Agents aren't disclosing. And I'm kind of seeing that theme come up over and over and over again. So again, just make yourself a note. ncrec.gov. Don't spend all your time reading the disciplinary actions. But I do think it helps to kind of see some of these things that we're talking about. Questions or comments on that? It's scary, isn't it? The wall of shame. I saw the other day, I didn't know this, but I saw the other day that they actually publish it in the local newspaper too, in your local newspaper. So they want to make sure that the public knows, don't they? The public can file a complaint right on the website. Now, just because somebody clicks on this button doesn't mean you're going to lose your license. The Real Estate Commission understands that there are 2, sometimes 3 sides to every story. So if somebody files a complaint and it's warranted, it's a violation of license law or commission rule, you will get what's known as the letter of inquiry. We jokingly refer to it as the brown envelope because that's how it comes, in a brown envelope. So you get the letter of inquiry. The letter of inquiry is your opportunity to respond to the complaint. Again, just because they click on the button doesn't mean you're going to lose your license. Take a big deep breath, right? You get the letter of inquiry. That's your opportunity to respond to the complaint. And you respond with your documentation. You respond with the transaction documents. You respond with your email communication, your text communication. You're not going to be able to pick up the phone and call the commission and say, but I didn't do that. They're not going to talk to you. Everybody with me? You respond with your documentation. Another reason, good reason for you guys to document everything, because that documentation could get you out of trouble. Guys, I'm going to be honest. I've seen several letter of inquiries on my career. I feel the need to say that none of them had my name on it, but as my role of an administrator, I've seen several. And every single agent I've known to get one has avoided disciplinary action because they had the proper documentation. And we can only imagine what if they didn't have the documentation. If you have nothing to reply to, they're going to take the word of the public over you. Everybody good with that? The onus is on me to prove that I'm innocent. Just as a side note, I have an app on my phone. Y'all write this down. It's called text to email. Text to email. You just go to, after class, please don't do it now, but you can go to your Google store or your iPhone store, your iStore, and just search for a text to email. And it allows me to convert text messages to a PDF that I can then email myself, load in my transaction file. So I have all communications with my clients, lenders, home inspectors, everybody with a date and a time stamp. Text to email. Question came in, what could you do so bad as to actually lose your license, violate license law and commission rule? Here's the thing, the complaint comes in, and depending on your response, it may cause them to launch further investigations, right? So they get a complaint on you and they may say, hey, while we're here, let's see the documents for all your transactions. And it could open an unintentional can of worms. Question comes in, are these firms, the files stored at the firms considering it's the firm's client? Absolutely. Absolutely. We use, there's .loop, zip form, SkySlope. We have programs that we use, and it's not my program, it's the firm's. So for example, my firm uses .loop, and every single time I create a loop, it attaches the firm to it. So they have access to those documents as well, because you're right, it is their transactions. They may or may not be getting the letter of inquiry. It just depends on the violation. I went to a educators conference with the Real Estate Commission a couple weeks ago. Y'all want to know what's one of the biggest complaints that the commission is currently hearing? They fussed at us a little bit, not us, but any chance they get. One of the biggest complaints they're seeing right now, consumers are complaining that their agents are cussing them out. And agents aren't doing it on the phone. Y'all, if you're going to cuss somebody out, do it in person or on the phone. Don't do it in an email. Don't do it in a text. Now they have documentation, right? So the Real Estate Commission just reminds us when they can that we have got to be the professional in the situation. There are other ways to handle unruly clients than cussing them out. Remember, you're the professional. Professionalism isn't quite a violation of license law and commission rule, but I'm kind of getting the feeling that the commission's tired of hearing these complaints. Isn't that crazy? Y'all don't cuss your clients out. Come on. Let's see. Can you use any of those text to email apps? Or is there a specific one? You know, you'll just have to play around with it. There's several out there. So you may just want to play around with it and see which one you like the best after class. When we get through Unit 10, we're going to come back to the commission website because when we get through Unit 10, we're going to talk about the process for you guys to start applying for your license, applying for your state exam. And again, it all starts here on the home page. Please don't do this yet. It's way too early. Give me a couple more weeks and then we'll talk about it and we'll see this again. Again, just good information out here. The resources tab, I think, is a great place to start educating the consumers, etc. ncrec.gov. I want to make sure everybody stays out of real estate jail. I never want to read about you guys in the disciplinary action. Fair enough? Because I'm going to read it and go, we talked about that. Question came in, if you're working for a firm and get an inquiry, can they let you go before the inquiry is done? Possibly. Possibly. So we're going to talk about your affiliation with firms at the end of Unit 7. Your firm's not hiring you. You're not an employee. They're affiliating you. So you have a different relationship. Firms can pretty much do whatever they want as long as they're in the confines of license, law, and commission rule, and they have a firm policy. So if the firm policy says that if you get a letter, they're going to let you go, they're going to ask you to not affiliate anymore, then sure. What if the client wants a strictly private transaction? Remember, who's the relationship with? The relationship is with the client and who? It's with the client and the firm. The firm is allowing me to work with their client. And when you affiliate with a firm, you're signing something saying all your transactions are running through the firm. Again, we'll talk about your affiliation. I got a little fear in you guys, just a little bit. Another reason why this stuff is so important, guys, again, we're building your foundation. We're building your foundation. I don't care what avenue you're going, residential sales, commercial, property management, does not matter to me. You need more training and education once you get your license. This is only the beginning. So our agency agreements are a two-way street. What do I mean by that? Legally, they're known as a bilateral contract. We're going to define that when we get into Unit 9. But for right now, let's just understand that a bilateral contract is a two-way street. Both parties have duties and obligations to each other. So we've talked about the agent's duties and obligations to the client. So what are the client's duties and obligations to the agent? Well, the principal or the client, again, used interchangeably. The principal is the client. They have to act in good faith. If they hire me to sell their house, they can't hinder me from my efforts. It's awfully hard for me to sell your house if you never, ever, ever allow a showing. If you don't let a single buyer come in the front door, you owe me that. Now, what if your family wakes up this morning and you all have a stomach bug? All right, I'm going to stop showings for a couple of days, right? Because we don't want to go in the house. We don't want to get that. We want that to clear out, right? So there is some wiggle room, some flexibility. I'm talking if you never, ever, ever allow a buyer, you decline all showings. It's hard for me to do my job. So the principal is promising the agent that they're going to refrain from hindering my efforts. The principal in our agency agreement also offers to pay me. Again, we'll talk all about your commission in Unit 8. I think one of the bigger problem topics of Unit 7 and 8, our agency agreements are employment contracts. They're employment contracts. We're being hired to do a job. And when I do my job, I deserve to get paid. Isn't that fair? Doesn't that make sense? So they're agreeing to pay me when I do my job. All of our agency agreements, the listing agreement, the buyer's agency agreement, and the property management agreement. Listing and buyers, we'll look at in Unit 8. Property management, we'll look at in Unit 12. Unit 12 is dedicated just to the property manager. Principals also have duties to third parties. Specifically, the seller can't lie to the buyer. Sellers don't have to disclose anything. Who remembers caveat emptor? Caveat emptor says, let the buyer beware. And what caveat emptor says is the seller doesn't have to disclose anything. I have seller disclosures that we will look at in Unit 8. But those seller disclosures, the seller has the option to say no representation. They can say, yes, this is broke. No, it's not broke. Or they can not disclose it and say no representation. What they can't do is lie. What could happen to your principal if they violate their duties, not only to you, but also to third party? They could be facing civil lawsuits, criminal prosecutions. They could also be responsible for your misconduct. If your misactions lead back to the principal and you had no way of knowing otherwise, they could be responsible. This is up to a court of law. So in other words, the injured party, may that be the firm or the other person in the transaction, could sue, hire an attorney and sue. Agents and most homeowners are also held to the Unfair Deceptive Trade Practices Act. And what the Unfair Deceptive Trade Practices Act says is that if we conduct our business in an unfair, deceptive way, we could be held liable. Again, owners don't have to disclose that they can't lie. You and I have to disclose everything. And we'll talk more about our relationship with sellers. So Unfair Deceptive Trade Practices Acts. Y'all just don't lie. It's pretty simple, right? Write that down if you need to. Don't lie. And encourage your sellers not to lie either. Any questions so far? The top of page 149, y'all please bookmark it, highlight it, circle it, dog ear it. Page 149, we start talking about classification of agency relationships. And these classifications of agency relationships are a problem topic all day long. So y'all make flashcards out of these. Our agency relationship has different levels. It has different tiers. And I need to know my role to know what I owe, or what I can do, I guess I should say, what I can do for my client. So the first tier, the first level, is known as the universal agent. Let's call the universal agent the unicorn. In a real estate transaction, universal agents are very, very rare. The universal agent is somebody that has full power to act on behalf of a person. When you think of the universal agent, think of, for example, having power of attorney over your parents. That would be an example of a universal relationship, a universal agent. Remember, the relationship is between the client and who? The firm. Is anybody in their right, sound, sober mind going to give full power to make all decisions, to do everything for me, to, for example, Keller Williams? This is why it's the unicorn. I'm not going to say we'll never see it. I'm going to say it's really, 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 really rare. I personally don't have an example of when we might see this, but remember who the relationship is with, the client and the firm. So the universal agent is the unicorn.
Yikes. She asked me if I wanted to turn over POA to her, make her a universal agent, because there was a really bad snowstorm. We couldn't make it to closing and it had been delayed, I think, twice.
You know, and that may be that's why I say never. That's why I say really, really, really rare.
Yeah.
Did you do it? Did you turn it all over to her?
No, I didn't. We found the one bank that was open in Boone. It was that big snowstorm this past January. And we made it to closing, just barely.
Good.
And it was a nightmare. But that she was like, well, you could give me power of attorney, or you could give the.
Now there could be a limited power of attorney that the agent asks for to go to closing, and pretty much I just have the authority to sign on your behalf at closing, but it's a limited power of attorney. That's not a full power of attorney.
So would that have been still a universal agent or a general? I mean, that would still have been like.
Well, that wouldn't have been a universal agent because universal is full.
Oh, okay. Okay.
I mean, if you have full power of attorney over somebody, it's because mom and dad are in the home, right? And they can't do stuff. That's what I'm talking
power
about.
of attorney for my parents. So I mean, I get that, but unfortunately, but
yep.
Okay, cool. Thanks.
Question came in. These kinds of agents require more education. Again, you guys, it's the unicorn. Think about what you're asking somebody to turn over. Like I said, the best example I can think of is full power of attorney for mom and dad. You have full power. You can make medical decisions, financial decisions. Is it time to sell your house, right? You have full power of attorney to do everything. And you're not going to give that to a firm. Universal is full. The next tier is general. The general agent has some decision-making authority. The general agent may be able to bind their clients. You have some power. Some examples of the general agent: the relationship between the agent and the owner in a property management situation. The owner is hiring the agent to manage their property. If the agent had to call the owner all day, every day for every little thing, this broke, what do I do? This tenant didn't pay rent, what do I do? This happened, what do I do? At some point, the owner's going to wonder, why the heck am I paying this person, right? That's why they hire an agent to manage their property, so they don't have to. So there's some authority, there's some ability to make decisions. The scope of that authority is spelled out in the property management agreement. What kind of decisions can I make? What kind of authority do I have? The agent and the owner have to discuss that. We have to agree to it up front before we enter into our agency agreement. Another example of the general agent is your relationship with your firm. Once you affiliate with a firm, you have some ability. You have an independent contractor agreement. And again, we'll talk about this at the end of Unit 7. For example, are we all good? The agency relationship is between the client and who? The firm. Everybody good with that? The firm allows me to sign the agency agreement on their behalf. The relationship is between the client and the firm, but because I'm a general agent, I have some ability. And some of that ability is to sign an agency agreement on behalf of the firm. So the universal has full, general has some. How much do you think special has? None. Very little. The special agent is the agent that's hired by the seller or buyer. Residential sales, commercial sales. The special agent is the sales agent. I cannot speak on behalf. I cannot speak for my buyers and sellers. I only speak on their behalf. I cannot make decisions on their behalf. Remember, as a residential sales agent, I am a fact finder. I provide the facts so they can make the decision. Never look at anybody in a sales situation and say, this is what we're going to do. This is what you're going to do. I provide the information for them to make a decision. I have limited, very limited. So again, the universal agent has all the power. The general agent has some. The special agent has none. If you're a special agent, you're a sales agent because you're working with buyers and or sellers. And again, what Stephanie was talking about, that's not uncommon. You're not getting a full power of attorney, but this isn't uncommon to get from sellers, for example. Not all sellers like to go to closing. Some do, but some don't. So what if something changes at closing? What if because they pre-sign their documents before we get to settlement? And what if something changes and we have to change a form? The thinking of having a limited power of attorney, it limits me to sign this form if necessary. I'm still going to call them and say, this changed. This is what's happening. Some firms practice that. Some firms don't. It could prevent delays in closing. That could be the big benefit of having a limited power of attorney. Questions or comments on that? 149. Highlight it, circle it, star it, make some flashcards out of it. Okay. So let's take our break. We'll take 10. We come back, we're going to keep going. Are we back? How are we doing? So far, so good? So I am going to take attendance. And picking back where we left off. We're now at the bottom of page 149, and we need to define some more words. We need to define some more words. Again, part of this, you guys, is just having a basic understanding of what these various words mean. And thank you for telling me. Please remember to tell me if you missed attendance, screenshot for attendance. Please remember to let me know in the chat that you're back. Brokerage is the business of bringing buyers and sellers together in a marketplace. When we brokerage a deal, we're connecting buyers and sellers. Maybe we're one agent doing it. Maybe there's two different agents in the transaction brokeraging the deal. We'll talk about those in just a second. Welcome back. Please let me know in the chat that you're back. Broker is what we all are in North Carolina. We are a broker state. We're all brokers. We just have different levels. We'll talk about our different levels. Some states are a sales associate state. The difference is pretty much the training, the scope of authority. But in North Carolina, we're all brokers. Commission is what we get paid. We could get paid a percentage of the sale. We could get paid a flat fee. Typically, we get paid when it closes. Again, we'll talk all about your commission. But typically, we get paid when it closes. So, what happens if it doesn't close? Do we get paid? Generally not. That right there is the hard reality of real estate. They don't all close. I wish I could stand here and tell you that they all do, but they don't. Again, we'll talk more about that when we get to your commission. Cooperating broker is when you have two firms coming together in the transaction. So firm ABC represents the seller, firm XYZ represents the buyer. We're two different firms, but we're working together to make this happen. We are cooperating. We still have the same goal, right? Even though we're competing firms, we still want to get our buyer and seller to the closing table. Another terminology we'll see in just a second, compare the cooperating transaction, the cooperating broker, to the in-house transaction, the in-house broker. In-house means both buyer and seller are coming from the same firm. They're represented by the same firm. So you're either cooperating with another firm in your MLS, or you're an in-house transaction. The firm represents the seller and the buyer in the same transaction. And again, we'll talk more about that in just a minute. In North Carolina, there are certain activities required to have a license. If you're involved in the transfer of real property for others for compensation, a real estate license is required. And when we talk about the transfer of real property, we need to think about various activities that revolve around the transfer of real property. And we can remember those activities by remembering LLBs. Those activities are list, lease, buy, exchange, auction, negotiate, or sell. You're listing real property for others for compensation. You're negotiating real property for others for compensation. You guys see what we're doing here? We're involved in the transfer of real property for compensation for others. All three of these activities are required to have a license. So if any one of these activities is missing, you don't need a license. For example, the for sale by owner isn't doing it for others, are they? They're doing it for themselves. So does the for sale by owner have to have a real estate license? No, because they're not doing it for others. What if you want to work for free? Don't work for free. But what if you want to work for free? A license would not be required. It's all three activities that are required. And please note, you guys, compensation, we tend to think of money when it comes to compensation. But compensation is just anything of value. Anything of value. Let's say you have a duplex, 2 units under one roof, and you want your friend to live in one of the units and help you manage the other unit. So you rent it out. One unit goes to your friend, the other unit goes to somebody else. And you ask your friend, or you tell your friend, in exchange for helping me manage this property, I'm not going to charge you rent. Is free rent something of value? Absolutely, especially in this market, yes? So even though compensation, even though you're not paying your friend to manage that property, you're offering them some form of compensation. And in order for your friend to do that, they have to have a real estate license. Okay. Compensation is just anything of value. All three activities are required. How we create agency relationships. There's a whole list in your book on 151. Again, we're going to spend more time talking about these. Probably the most common way that we create an agency relationship is the agency agreements between the firm and the client. You could have a listing agreement, a buyer's agency agreement, a dual agency agreement, property management, or a tenant agreement. These are the agency agreements that form the relationship between the client and who? The firm. We'll talk about listing, buyer agency, and dual as we continue through 7 into Unit 8. We'll talk about property management, tenants, when we get into Units 11 and 12. So this is one way to create an agency agreement, an agency relationship, is to have an agency agreement between the firm and the client. Another type of agency relationship could be between you and your firm. When you affiliate with your firm, and again, we'll talk about that at the end of this unit. When you affiliate with your firm, you're going to have an in-house employment contract, maybe also known as an independent contractor agreement. Even though your firm is not hiring you, you still have to agree to your relationship. Remember, your relationship with your firm is that of a general agent. In your brokerage contract, your independent contractor agreement has to spell out what your authority is. What are you allowed to do under the scope of your firm? I think one thing, if I could get you guys to wrap your brain around this, all firms are different. There is no firm that's the same. They all operate differently. And as long as they're as long as they're within license law and commission rule, their firm policy dictates how they operate. I can't stand here and tell you all firms do this and all firms offer training. All firms, this is the compensation split you're going to get. They are all different. So you have to agree to that relationship. That's what your in-house brokerage employment contract is. And then the other type of relationship between brokers and firm that we have is a cooperation agreement. When you start working with a seller and you list their property for sale, you're going to put it in the multiple listing services. We'll talk about MLS, multiple listing services, in Unit 8. And when you put that listing in MLS, you're advertising the listing to everybody that's a member of your MLS. Triad MLS, Triangle MLS. Charlotte's is called Canvas. So there's different MLSs across the state. You put your listing in, you're advertising that listing to all the agents within that MLS. And in addition to the listing, you're advertising, how much commission are you gonna pay him? If you bring me this buyer, this is how much I'm gonna pay you. We're cooperating. We're working together to bring this buyer and seller to closing. That's our job. That's what it's all about. Again, we'll talk about multiple listing services in Unit 8. We'll talk specifically about working with sellers. So we'll see that in Unit 8. You could also create an agency relationship by an implied agency agreement. This is based on the actions of the party. Our relationship was not stated in words. We just started acting like we had a relationship. Implied agency is not allowed in North Carolina. All of our relationships are created purposely, and they're all sealed with some kind of something in writing. The scope of our authority, again, we've already talked about implied. Look about halfway down here. An implied agreement is just created by the actions. You just start acting like an agent for somebody. That's an implied agreement, not allowed. What we do is an express agreement. And in an express agreement, the terms are clearly laid out. The terms are stated. I'm going to do this, this, and this for you. In exchange, I expect to be paid when it closes. Express agreements can be orally expressed. They can also be expressed in writing. We do have a case that we'll talk about where a relationship can start as an oral agreement, but it eventually has to be put in writing. All of our agency agreements eventually have to be put in writing. But even if it starts out oral, it's still express. So you can't just start acting like somebody's agent. That's an implied agreement that's not allowed. If you're in an oral buyer's agency agreement that we'll talk about, you still clearly lay out the details. You still verbally communicate. I would follow it up with an email, because what do we document? Everything. So we'll talk about an oral relationship in just a bit. They're both still express. Apparent authority is a situation where the client is well aware of your scope. They're well aware of what you can do because you expressly laid it out. You clearly laid it out. But even though the client is aware of what you can do, they still request you to go beyond your limits. That's apparent authority. This is why we have to have an understanding of our duties and responsibilities. We need to be aware of what we can and cannot do. For example, let's say I have a listing and I tell my seller at the very beginning, I cannot accept an offer on your behalf. Why can I not accept an offer? Because I'm just a special agent, right? So when I get an offer in, I have to discuss it with my seller. I can't just say, yeah, that looks good, we accept. Everybody with me? That's what being a special agent is. Even if it's a full price cash offer, the dream offer, I cannot accept it without discussing it with my seller. And I have this conversation up front. And my seller says, okay, well, we're going to go out of town this weekend. So if anything comes in over X amount, just go ahead and accept it for us. That's them asking me to act as an apparent authority, in which my response is, I'm very sorry, I can't do that. You need to check in on me, check in with me. We need to talk if an offer comes in. You guys with me? We tell our principal what my duties are, and they say, but I want you to do this. When it comes to our compensation, the person that hires me is the one that gets OCAR. The person that hires me may not be the one paying me. OCAR follows the agency agreement. OCAR does not follow the money. Typically, the seller pays the listing firm. The listing firm shares their commission with whomever's bringing the buyer. So if I'm working with a buyer, I have a buyer's agency agreement, but I'm technically being paid by the seller. The buyer's the one that hired me. The seller's the one that's paying me. Where's my loyalty? My loyalty is to the one that hires me. In that case, the buyer. The seller may think, I'm paying you, you have to do it. No, no, no. I only owe you OCAR when you hire me. And as we said earlier, you may be able to have an agency agreement that's oral at first, that we will talk about, but you got to put it in writing if you want to be paid. Do you want to be paid? Everybody shake your head yes. So you can start with an oral agreement with a buyer. We'll talk more about that. But you have to get it in writing if you want to be paid. Again, agency agreements are employment contracts. The client is hiring the firm to perform a service. And that's where my loyalty is. Agency agreements don't go on forever and ever and ever. At some point, they have to end. The whole list of how they end is on page 152. I figured, why not recreate the wheel? So page 152 The first bullet point there we see is completion or fulfillment of the purpose of which you were hired. Once you get your seller or buyer to closing, I've done my job, right? The seller hires the firm to help them list and sell their property. The buyer hires the firm to help them locate and purchase a property. So once we go to closing, our purpose has been fulfilled, right? I did what you hired me to do. I don't owe you agency when we're done. I don't owe you agency when it closes. All agency agreements have an termination date, an expiration date. And when they're over, they're over. So if our expiration, our agency agreements goes until April 5th, that means at 11:59 tonight, we are done. I don't owe you anything. You don't owe me anything. When it expires, it's over. Can we agree to extend it? Of course we can. Do we have to? No. Expiration dates, how long you have your agency agreement may come down to firm policy, and it's got to be agreed on by the principal. We'll see that when we look at our agency agreements. Termination of agency, mutual agreement of the parties. Can you fire a buyer? Can you, the individual agent, fire a buyer? No. Why? Because it's not your buyer. Whose buyer is it? It's the firm's buyer. So if we mutually agree to terminate, it's because you're broker in charge. Maybe you and your client aren't getting along. Not everybody's compatible. Not everybody plays nicely, plays well together. So it might be that you're not compatible with your client. You can't just let them go. You got to have your firm, and your firm may try to reassign them to another agent in the office, try to salvage that deal. But it's not your relationship to terminate. Do I have everybody on that? It's your firm's buyer. It's your firm's seller. Breach of either party could terminate the agency relationship. If either party does or does not do what they promised to do, breach could terminate it. Destruction or condemnation of the property. If you have a listing and the house burns down, you don't have a house to sell anymore, do you? So that may terminate the listing agreement. Maybe you relist it to sell the land, but that would be a different relationship. And then the last thing is death or incapacity of either party. Again, the relationship is between the client and the firm. So if the individual agent passes away, the show goes on. The firm would have to dissolve. The firm would have to shut their doors in order to terminate that agency. So as we mentioned, when agency is over, it's over. It's not going to go on forever and ever. I don't owe you old car for the rest of my life. When it's over, it's over. Various ways of how it can end. I'm going to go off textbook for a second. If we go off textbook, NIB means not in textbook. Our agency duties typically end when agency does. There are some exceptions. If you have an unfulfilled promise or obligation, the law of agency says you need to satisfy that. Let's say we go to closing today and I promise I'm going to do something tomorrow. I can't get out of it because we went to closing today because our agency agreement ended today. If your agency agreement extends while you're under contract, I'm sorry, your agency agreement expires. Let me rephrase that, please. Your agency agreement expires while you're under contract. We still have a duty to get our clients to closing. Best practice here would be to extend your agency agreement to get through closing. Have that in writing. If my agency agreement ends, let's say I had a listing and I couldn't sell it, the listing agreement expires. I can't now turn around, even though we don't have an agency agreement anymore, and use what I know about the seller in self-dealing. I can't use the seller's information against them. Maybe I know why the seller's selling. I couldn't sell their house, and now I'm going to take that and use it to my advantage to offer them a low price. That's self-dealing. Remember what OCAR says. The other thing that is expected to continue is that duty of confidentiality. Just because our agency agreement ends doesn't mean that I have a golden ticket to run down the street shouting out my former client's confidential information. Would that be cool? No. So just because our agency agreement is over does not give me the golden ticket to blab. But let's imagine a scenario. I was the listing agent. I couldn't sell the house. Our agency agreement expires. Seller and I part ways. The seller later lists with a different firm. And now that they're listed with a different firm, I bring my buyer client. Who's my loyalty to today? The buyer. In that scenario, I owe it to my buyer to tell them what I know about the seller. Everybody good with that? I don't have a golden ticket to blab, but I always owe my current client OCAR. And OCAR does include confidentiality. Remember, I tell my client everything about my customer. I tell my customer nothing about my client. So in that scenario, today, the buyer's my client, the seller's my customer. Everybody good with that? I know that one sits kind of hard. I'm bumping on some moral compasses right now, and I'm aware of that. But you always have to ask yourself, who is my firm representing today? When in doubt, who do I owe OCAR? What do I do? Look towards the firm, because that's where the relationship is. Question came in about the seller of the property, both. I always disclose material facts. But if I happen to know, which considering I had this listing, I probably very well know why my sellers are selling. Excuse me, why my former sellers are selling. I may even know how much under asking price they're willing to accept. When an offer comes across the seller's desk with my name on it, do they have to accept it? Could they look at that and go, oh God, we've already dealt with this girl once. We don't want to deal with it again. Yeah, the sellers don't have to accept any offer. And if they're not comfortable in that situation, they may not choose to accept my buyer's offer. You guys see what I'm saying? Again, we'll talk about contract formation, seller's options, buyer's options. That's all unit 9 and 10. What website would you recommend? So once you get your license and you affiliate with your firm, you'll have access to the multiple listing services, MLS, and there's all sorts of back-end stuff that we have in MLS that you guys don't see on like Zillow or realtor.com, things like that. So you can get more information. Yep. But until you get licensed, I mean, there's thousands, Zillow, realtor.com, Most big companies, so you can go like Alan Tate's website, Coldwell Banker. Just know you don't see everything that you will see once you get licensed. The whole new world of possibility is going to open up to you guys once you get your license. Is that exciting? Before you get an MLS though, you got to get your license. Trying to keep you guys grounded. So another scenario. I work with the buyer. I have a buyer client. I can't find them a house. We work together for pick a time, 2 months, 6 months, whatever we agree to. And within that time, I can't find them a suitable property. Our buyer's agency agreement expires. I later take on a listing. The seller hires me to sell their house, and another agent brings an offer with my former buyer. Who's my loyalty to today? Today, it's the seller. Do I tell my seller what I learned about my buyer in our time together? Anything that could affect their decision-making and accepting this offer? You always got to stop and ask yourself, who does the firm represent today? Still off book. There's different types of companies out there, I guess. There may be a sole practitioner. How many people work for a sole practitioner as a sole practitioner? Sole means what? Sole means one. So it's the individual agent not affiliated with a firm. They're known as a sole practitioner. Depending on how they're set up, how they're functioning, the agreement is between the sole practitioner's company and the consumer, the client. So we have choices. Once you get your license, once you get some experience under your belt, and I will talk more about that later, we have some choices about how we can practice. You can stay affiliated with a firm. You could go out on your own. Anybody thinking about going out on your own one day? You and just you? One man stands alone, a couple of you? You're a ways away from that. We're starting to see a lot more sole practitioners pop up. You go out on your own. You work for you. Compare that to the firm. Keller Williams, Allen Tate, Coldwell Banker. So the agency agreement is between the firm. We're going to talk about subagents in just a bit. What I'm referring to here, let's go ahead and start creating a scenario. Let's say all of you got your real estate license today. That's a big day, isn't it? So all of you get your license today. Yay, congratulations, you guys. You all got your license today. And upon getting licensed, you guys decide to come work for me. I am the firm. So you affiliate with Julie's Real Estate Shop. Is going to be the name of my firm. Who is the agency relationship with? It's with the consumer and me, isn't it? Me. I am the firm. I allow you to work with my sellers. I allow you to work with my buyers. This form of subagency, again, that we will talk about in just a few more minutes. What this form of subagency says, when one of you gets a listing, in a sense, we all get the listing, right? Because whose listing is it? Mine. So one of you, I'm going to allow to work with my sellers. Does that mean the rest of you can go out and mistreat my sellers? The rest of you can go out and be deceptive? No, because they're my sellers. Don't you mistreat my sellers. So by the very nature of that relationship, one of you gets to be the listing agent to work with my seller. The rest of you are subagents. Your relationship is by default. That's one form of sub-agency. Again, we'll talk a little bit more about sub-agency in just a second. Question came in, how does the firm decide to give the listings to? For the most part, we're out generating our own business. If firms do help you generate business, they may charge a referral fee, maybe they have different compensation plans depending on where the business came from. If you generate your own seller, I'll pay you a little bit more versus me handing it to you. So we're back in the book, bottom page 152 over into 153, and we're going to start talking about agency relationships. And first off, I want to point out the nice little handy dandy chart on page 153. Again, I think your book does a good job with visuals. So anytime you see charts or figures or in practice or for example, I think those are good to pay attention to. So the top of 153, you have a little summary of what we're getting ready to talk about. I feel the need to say, put a caution out there. When we talk about these different types of agency relationships, we may discuss a type of agency relationship and you may go, I'm not going to affiliate with a firm that does that. Are you kidding me? I need you guys to remember going into this discussion that your test is not going to ask you what you're going to do, how you are going to conduct your business. Your test is going to ask you how you can conduct your business. So what we're going to do is talk about the different scenarios, the different possibilities for agency relationships. Clients come from listing sites, possibly. Sign in the front yard, websites, they come from all over. Is everybody good with that? Y'all get out of your own way. I think when we have some of these conversations, you guys say, I'm not going to do that. And then you get in your own way and we get to the test, you're so against it. And you answer the question how you're going to do it. But your test doesn't care about how you're going to choose to do it. Your test is going to ask you how you can do it, how you can practice. Do I have everybody on board with me? Everybody going to get out of your own way? Y'all like to argue with a test question. Y'all blow my mind. Y'all love to argue with a good test question, don't you? Yeah, I see you laughing. If you know, you know. Get out of your own way. All right, so talking about the different agency relationships. The first type of agency relationship we have is an exclusive seller agency. In an exclusive seller agency, the firm only represents sellers. All buyers are customers. Exclusive seller agency will never have a buyer client. All their clients are sellers. Now, if you're here in the Triad, Triangle, Charlotte, some of our bigger areas, this is rare to see. But when you get into smaller rural areas, this is a lot more common. Carolina School of Real Estate has an instructor that lives near Troy. Y'all know Troy down 109. Bigfoot likes to hang out down around those parts, you know. That's a more rural area than Winston-Salem. And the firm that instructor works for is an exclusive seller agency. The only clients they have are sellers. So think about what you're telling the sellers. You're saying, as long as you have a property to sell, I'm going to represent you. I'm going to give you my all. I'm going to put you in first class. If you ever want to buy a house, I can help you, but I'm going to have to downgrade you, right? Buyers, in this case, don't go in first class. Buyers go in coach. Maybe I can refer you to somebody else down the street that does work with buyer clients. Maybe I have that kind of relationship. By the way, I want us to start really paying attention to this word exclusive. When you see this word exclusive, if you're dating somebody exclusively, how many people should you be dating? Women tend to answer that faster than men. Isn't that something? Every single time. If you're dating somebody exclusively, you should be only dating one person. Yes? And it's important that we understand in our agency relationship, exclusivity is a one-way street. If we have an exclusive seller agency, how many firms can the seller date? The seller can only date one firm. And that's why I mean by a one-way street. The firm can date as many sellers as they want to. But it's an exclusive relationship because the seller can only date one firm at a time. Questioning about commission, it's all up to the firm's policy. Commission is completely negotiable and it's up to the firm's policy. So exclusive seller agency, the seller's dating one firm, the firm only dates sellers, multiple sellers. The firm doesn't date buyers. Do I have everybody? What do you think the other side of that coin is? Exclusive buyer agency. In these types of relationship, the firm only represents buyers. The firm is showing the buyer's property that's either listed by other firms or for sale by owner. The firm will not have a listing. The firm only works with buyers. Maybe it's exclusive, maybe it's not. Again, buyers get a little tricky. We'll spend some time talking about the different ways we can work with buyers. The relationship that we're referring to here is that of the firm. They don't have listings to show. They're relying on other firms' listings or for sale by owners. I think we see this sometimes in teams. Some teams are set up where they have some agents that only work with buyers. They have some agents that only work with sellers. Again, what we're telling the consumer, if it's an exclusive relationship, as long as you're my buyer, you're my client. However, if you have a house to sell, I can't help you. Sellers are either represented by another firm or they're for sale by owner. If you sell the house I helped you buy, I could probably refer you to an exclusive seller agency company down the road. Yes, I can collect a referral fee. How much? Depends on firm's policy. I think mostly what we see in these parts, again, Triad, Triangle, Charlotte, some of your bigger areas, is single agency in which the broker or the firm represents one or the other. I can work with both. I can represent both, but it's one or the other in a transaction. There are scenarios that the firm represents both in the same transaction, and we are getting there. A single agency, the broker or the firm represents one or the other, never both in the same transaction. Questions so far? So let's start talking about this idea of sub-agency. There's two different scenarios of sub-agency. The first one is what we just talked about. First off, let's define sub-agency. A sub-agent is an agent of an agent. You're an agent under an agent. The word sub means under. Think like submarine, for example. You're an agent of an agent. And the scenario that we just gave, you all are licensed and you now work for me. You work for Julie's Real Estate Shop. Welcome, welcome aboard. Good to have you. When one of you gets a listing, doesn't matter how you get it, one of you enters into an agency agreement on behalf of the firm with the seller. Remember whose listing that is. Whose is it? It's mine, Julie's Real Estate Shop. So one of you has been coined as the listing agent. The rest of you are sub-agents by default. You're agents of the firm that has the listing. Now, does this mean the sub-agent, does this mean the listing agent can boss the rest of you around, tell you what to do, tell you to make copies, go get me coffee, do my open house on Sunday? Does the listing agent get to tell the sub-agents what to do? No. Why? Because you don't work for the listing agent. You work for me. Can I tell you what to do? To an extent. We're independent contractors, so to an extent. This type of sub-agency is a relationship by default, because it's not the listing agent's listing. This is one form of sub-agency. Questions on this form of sub, I think this is the easiest one to get. We'll talk about the other one after break. It's a relationship by default. Could a sub-agent hold an open house for the listing agent? Yeah, because the relationship with the seller is with the firm. I tell you what, when you guys affiliate with your firms, when we start doing open houses again, when we get enough inventory that we can do open houses is a great way to meet buyers. Maybe they have an agent, maybe they don't. When you guys affiliate with a firm and we start having inventory to do open houses again, I want you guys to march up to the top producer of your firm, of your office, and I want you to look them square in the eye and say, I love doing open houses. You know what top producers don't like to do? Open houses. You know what? They don't have to. They've served their time. You know what's a good thing for newbies to do to help meet buyers and help get started? Open houses. You can as a sub-agent. Everybody with me? Because it's the firm that owes that seller old car. It doesn't matter which one of us is conducting that open house. All of our relationship is with the seller, either the listing agent or the sub-agent. Everybody good so far? Did y'all write that down? I heart open houses. It's a great, my very first buyer client ever came from an open house. They didn't buy that house, but they called me on Monday and they said they liked me and they liked my spread. Can I help them find another property? To which I said, yeah. So open houses pay off. It's a good way for you guys to meet buyers. We just got to have inventory again, and it's coming. We'll get it. I promise. All right. So let's take our break. When we come back, there's a different form of sub-agency. So when we come back, we'll talk about that. All right. We're back. This is good stuff, isn't it? This is our day to day. All right. So let's take attendance. So again, one form of subagency, one way we can explain subagency. When one of us gets a listing, we all get the listing because it's the firm's listing. When one of us gets a buyer, we all get the buyer. And please let me know that you're in the chat, that you're back. Thank you. So when one of us gets a buyer, we all get the buyer, right? Because it's the firm's buyer. That's one form of subagency. Questions on this? The other form of subagency when we talk about brokerage, when we talk about bringing buyers and sellers together, we all have one responsibility. And that responsibility is to find sellers, this ready, willing, and able buyer. That's our job. When I wake up every morning, that's the duty that I owe all the sellers, everybody that has a listing in the Triad MLS. That's my job, is to find them a ready, willing, and able buyer. And I tend to think of this ready, willing, and able buyer as a three-legged stool. If we kick out one of the legs of this stool, what happens to the stool? It falls over, right? So ready, willing, and able buyer is one stool, one three-legged stool. We have to have all three pieces. So again, when I wake up every morning, I don't care if it's a seller that lists with my firm or if it's a seller that lists with a different firm. When I wake up every morning, I owe all the sellers in the Triad MLS the duty of finding them a ready, willing, and able buyer. The only exception to this would be any buyers that I have a buyer's agency agreement with. Those buyers, I owe a duty to find their home, help them locate and purchase a home. That's my duty, that buyer, because they hired me. But all the buyers don't hire me, do they? Currently, right now where I stand, I do not have an existing buyer's agency agreement with any buyer. So that's why I say, when I wake up this morning, my duty is to find all the sellers in the Triad MLS a ready, willing, and able buyer. If I bring an unrepresented buyer to the transaction, I'm not a buyer's agent. I can only be a buyer's agent if I have a buyer client. But what if the buyer doesn't want to hire me? What if the buyer wants to be my customer? I need to define my role in the transaction. If I'm not a buyer's agent, if I'm not bringing the buyer client, then I'm a sub-agent that's bringing the buyer customer. If I'm bringing a buyer client, I'm a buyer's agent. If I'm bringing a buyer customer, I'm a sub-agent. I am a sub-agent of the seller. So let's talk this through. You got the seller that hired the firm and the agent. And let's pretend we have this wall that divvies the two parties. The buyer shows up as a buyer customer, which means they don't have representation. They're unrepresented. Customers are unrepresented. If I'm the one bringing this buyer, that should say customer, pretend that I spelled that right, please. If I'm the one bringing this buyer customer, my role is that of a seller's subagent. The buyer's hanging out alone, right? Why? Because the buyer doesn't have representation. The buyer chose to go through this transaction unrepresented. As the subagent, who is my loyalty to? The seller. Because the buyer, for whatever reason, has chosen not to hire me. We're going to look at a couple examples of this. Guys, this form of subagency takes you a minute to wrap your brain around. Y'all, please don't chuck your pencils down and say, I can't do this just yet. You probably just met this. So give it just a minute to marinate, let it soak in. Not all firms are willing to work with a subagent. They have to advertise in the MLS if they are willing to work with a seller subagent. And the reason why a firm may not choose to work with a subagent is because something called vicarious liability. And what vicarious liability says is that the seller or the firm could be responsible for the subagent's actions. Remember, the subagent could be with a different firm. Maybe I don't know this subagent. I have no idea who you are. I don't know what kind of training you've received. I don't know if you know what you're doing. It's up to the firm's policy if we allow an agent to bring an unrepresented buyer. I'm going to say that again. It's up to the firm's policy if we are allowed to bring an unrepresented buyer. If you are involved in this transaction, you have to have a role. If the buyer doesn't hire you, then your role, if allowed, is that of a seller subagent. So I'm going to show you guys a couple things. Let's see, let me address a question here. Can seller and buyer move forward, the buyer still being the customer? Absolutely. Absolutely. The buyer's just hanging out over here alone. The buyer doesn't get old car in this case, do they? The buyer gets what? Honesty, fairness, and the disclosure of material facts. So in this form of subagency, they don't necessarily work the same firm. Absolutely. That's absolutely correct. Maybe the subagent works for the same firm. Maybe they don't. Because again, remember what my job is, what my duty is every morning when I wake up, to find all the sellers, everybody that has an active listing in the Triad MLS. I owe them that duty to find them that ready, willing, and able buyer. Maybe some subagents come from the same firm in this scenario. Maybe they don't. Are they allowed? It's up to the listing firm. Some firms will say, I don't care, bring me a buyer. I don't care where the buyer comes from. Is it your customers, your client? I don't care, just bring us a buyer. Other firms may say, I'm terrified of this vicarious liability thing. I don't want to be responsible for your actions. And that's what vicarious liability says. Question comes in, does the subagent still get paid if the firm allows them to bring a buyer customer? And again, I'm getting ready to show you in just 1 second how you know, because you know, when you have a buyer customer and they want to see 123 Main Street, you can log into MLS and see if subagents are welcome. So you don't even have to show the, if it says, and again, I'll show you the verbiage, but if it says subagents aren't welcome, then you can't show that buyer customer. Most buyers choose to be represented. Most buyers choose to be represented. Most buyers choose to hire the firm. I think an example of a buyer that may choose not to be represented, a buyer that may choose to be a customer, is maybe an investor, somebody that does this for a living. They don't need me to advise them on price, what I think they should buy, help them find a home inspector. They have all that. They pretty much just need me to get them in the front door, right? They need me to show the property. They need me to let them in so they can do their inspections. So let's pause for just a second. Let's take a look at just a couple things. And the first thing I think that may help to point out, I'm going to skip ahead just a bit. And if we go into the Unit 8 material, and we will talk about this when we get into Unit 8, but I think it helps to see what I'm saying. In Unit 8, I have a sample MLS input sheet. So again, we'll talk about this when we get into Unit 8. But MLS advertises the type of agency that the firm and the seller is willing to work with. Agency type. Who is the firm willing to work with? Buyer agent only, sub-agent only, or both? Both says, I don't care if you're a buyer's agent or a sub-agent. So if you have this buyer client, if you have this buyer customer and they want to see 123 Main Street, and you go into 123 Main Street and buyer agency only is checked, you as the sub-agent are not welcome to show the property, because the firm and the seller has said, we only want represented buyers. So if you don't have a represented buyer, thanks, but no thanks. If it says both, then you're welcome to take your buyer customer. If it says sub-agent only, I think that's a mistake. I think that's an error. Why would you not want represented buyers? There's no liability there. So I always think that's a mistake. I don't see that. I don't believe I've ever seen that. So sub-agents are assisting the buyer customer to get through the transaction. And you know, before you ever show up, if you're welcome or not. All you got to do is look in MLS and it'll tell you what agency type is welcome. The other thing I want to show you guys, I'm skipping way ahead now to Unit 10. Unit 10, we're going to look at our offer to purchase and contract. We'll talk about this when we get into Unit 10, but I want to fast forward down to the end, and we have a place for the agent to identify their role. For the firm to identify their role. So when you submit an offer, please remember, the selling firm is the firm working with the buyer. Remember, selling versus seller. We looked at that distinction. So the selling firm is the one working for the buyer. The selling firm identifies their role. They're either acting as the buyer's agent, the seller sub-agent, or the dual agent. We're going to talk about dual agency in just a second. The selling firm has to check their role. We have got to identify our role in this transaction. So if you're acting as a seller sub-agent, that buyer is your customer. Again, maybe you're with the same firm, maybe you're not. How much are you going to get paid? It spells it out in multiple listing services. The MLS is the listing firm's agreement to compensate me. So we'll see our contract in Unit 10 when we get there. So let's make sure, let's go through this again. The seller sub-agency. I'm going to go back for just 1 second. Now that you guys have this all written down, there's two different ways to look at sub-agency. The first way, when one of you gets a listing, we all get a listing. One of you is the listing agent, the rest of you are sub-agents. It's the relationship by default because of the firm. So one of you gets a listing, one of you is the listing agent, the rest of you are sub-agents because you're still under the umbrella of the firm. The other form of sub-agency is the agent bringing their buyer customer. The agent is a sub-agent of the seller. When we look at our listing agreement in Unit 8, we're going to see that the seller and the firm have to agree to sub-agency or not. They have to agree to allow it or not. Again, some firms' policy allow it, some don't. What questions do I have?
Julie, I just gotta say, I finally understood sub-agency.
Yay. It took
That
you,
is a big
you got to
deal.
hear it a few times, right?
Yes.
Thank you. Thank you for that testimonial, because some of you are going, huh? And you should be. Again, you just met this like what, 5 minutes ago? So I hope you're going, huh? I hope you're not going, yeah, I got this if you just met it for the first time. That makes me a little nervous. So thank you so much, Becca, for sharing that, because you got to expose yourself to it. You got to read it again. You got to hear it again. You got to call me and ask me a question again. You guys with me? You got to hear it and see it over and over again. Guys, we're friends. We can be honest, right? There are agents out there practicing right now with a license that aren't doing this right because they still don't understand it. Does that make it okay? Everybody, please shake your head no. How do you think the real estate commission would feel about that? Most of what we've been talking about so far is, especially in this scenario, is the idea where two different firms are involved in the transaction. One firm is representing the seller. The other firm is either representing the buyer client, acting as a buyer's agent, or they're working with the buyer customer, acting as a sub-agent. The next scenario we're getting ready to go into is when both seller client and buyer client are represented by the same firm. Seller client, buyer client, represented by the same firm. And before I flip the slide, let's put a visual in your head. Let's use a basketball example. In honor of Kansas, let's use a basketball example. When you're watching a basketball game or any sporting event, is it easy to look at the court and see that there are two different teams? Last night, you could look at the court and you may not know who they are, but you could see that's UNC and then this is Kansas, right? You could tell that there were two different teams. That's a scenario we've been referring to all along. The seller is one team, the buyer is a different team, two different teams. Everybody with me? In this scenario where the seller is represented by a firm and the buyer is represented by a firm, the firms are acting as the coach. The firms are out there, advising their clients, telling their clients what they think they should do, providing the facts, getting them the information, helping them through the transaction. When you have a scenario that both seller and buyer are represented by the same firm, the seller and buyer's role doesn't change, but the firm's role does. If the firm is representing both buyer and seller in the same transaction, the firm stops being the coach and they start being the referee. Is the referee still an important part of the game? Do we need the referee to make sure everybody gets through the game, following the rules, doesn't everything they're supposed to? Is the referee telling the players what play to make next? Is the referee giving advice? Is the referee saying, this is how you can win? Trust me, I got you. When we get into a situation where the firm represents both, the firm's role has to change. And that situation where the firm represents both is dual agency. Before you guys start writing, please give me, I shouldn't have flipped yet. Let me have this discussion on dual agency, and then I'll open it up for questions. Okay, so bear with me for a couple slides. I will open it up for questions. Dual agency is an in-house transaction. In-house means there are how many firms? Just one. A dual agency relationship means that the firm represents the seller client and the buyer client. The simplest, I cannot get dual any simpler. One firm, one transaction, two clients. The seller has hired the firm to sell 123 Main Street. The buyer has hired the same firm to help them purchase 123 Main Street. Please give me a second on questions. Dual agency may be one agent working with both buyer and seller. Dual agency may be two agents in the same firm, one working with the buyer, one working with the seller. It's not about the agents though, is it? It's about the relationship between the client and the firm. Dual agency doesn't just happen. Dual agency is intentionally created with informed written consent. I'm going to say that again. I'm probably going to say that 7 more times before it's over with. Dual agency is intentionally created with informed written consent. Intentionally created means it doesn't just happen. It doesn't happen on accident. And it's intentionally created because we have informed written consent of both parties. The seller has given us consent to do dual agency. The buyer has given us consent to do dual agency. Does informed consent mean we're going to look at our buyers and sellers and say, we're going to do dual sign here? Is that informed? We're going to do dual sign here. So informed means we're going to explain dual agency. We're going to have a conversation about dual agency. Here's the deal with dual agency. Again, the firm's role changes. The firm goes from being a coach to a referee. The firm cannot offer advice. The firm loses their ability to be an advocate for both parties. Remember what the law of agency says. I serve my client. I owe them old car. This goes back to the New England days where we served one king. How do we serve? How do we give both clients old car? How do we serve two kings equally and fairly? And the answer to that is the firm's advocacy goes away. I'm still on the court. I'm still making sure that my clients get through the transaction. I'm no longer offering advice. There's no advice I can give one party that won't harm the other. Let's say, for example, guys, can we please hold off on questions? Because I very well may answer it. Can we just listen for a second, please? I'll get to all questions, I promise. There's no advice that we can give one client that won't harm the other. Let's say, for example, you're in a dual agency situation and you're the agent of the firm that's working for the buyer. And the buyer wants to make an offer. And they look at you and say, how much should I offer? If you say, we'll offer under asking price, you've harmed the firm's seller client because you're not getting the most amount that you can for the seller, right? If you say offer asking price or more, you've possibly harmed the firm's buyer client. The key to dual agency is advocacy goes away. There is no advice that can be offered. In dual agency, the firm has been tasked with representing both the buyer client and the seller client in the same transaction with equal loyalty. That's where the trick is. That's where it gets difficult. Again, once again, remember, whose listing is it? Whose buyer's client is it? It's the firm's. And when the firm is in a situation where they are to represent both parties with equal loyalty, we have to enter into this relationship with informed written consent by both parties. When we look at our agency agreements, we're going to see seller and buyer have to give us permission to do dual agency. And if either party says no, then we can't do this transaction. The firm has the task of representing both parties in the same transaction without compromising either principle. So let's talk about what this looks like. Let's pretend you work for a firm. Let's pretend there are 3 office locations, one in Greensboro, one in Winston, and one in High Point. You have 3 different office locations, but we're all still with the same firm, right? We're all still under the umbrella. So the firm isn't necessarily under the roof. It's under the umbrella of the firm. One firm, 3 office locations. And let's say you are at a listing. Let's pretend you work at the High Point branch and you're at a listing appointment and you have this discussion with your sellers about dual agency. And you tell the seller, if a buyer represented by my firm wants to make an offer, then we're going to be in a dual agency situation. You explain it, you go through the listing agreement with them and you explain it. And at the end, the seller says, no, the whole reason I'm hiring you is to be my advocate. The whole reason I'm hiring you is so you can offer me advice. And now you're telling me there's a scenario where you can't be my advocate? No, absolutely. I am not agreeing to dual agency. That's fine. That's the seller's right. What the seller needs to understand is that no agent within the firm can bring their buyer client. The seller has said no to that already. Could we bring our buyer customer? Do your head. Can we bring our buyer customer? Yeah, we can't bring our buyer client because remember, dual agency, one firm, one transaction, 2 clients. So if the buyer's a customer, I'm not in dual agency, am I? If the buyer's a customer, it's not an issue. So you tell the seller, look, my firm has 3 office locations. And between the 3 locations, there are 300 agents that work in these 3 office locations. By you saying no, you're saying none of these agents within the firm can bring their buyer client. The seller may change their mind later. We'll talk more about that in just a second. let's flip that coin. You have an agency relationship with a buyer. That buyer's your client. You've been out for 3 months showing them property listed by other firms. All of a sudden, one day, a new listing comes on the market that your buyer's interested in that is listed by your firm. Your buyer client calls you and says, ooh, you guys got a new listing, but I want to see it. The seller has agreed to allow dual agency. We have that in our listing agreement. Now that the buyer wants to see one of the firm's listings, now we need to discuss dual agency with our buyer, right? And you tell your buyer, we've been together for 3 months. I've been your biggest advocate. I've given you all the advice I have. If we move forward with this transaction, my advocacy goes away. My role changes from being your coach to a referee. If the buyer says, no, we're not going to do that, I can't show them that listing. That's the repercussions of them not agreeing to dual. They're limiting their pool. They're limiting the listings they can see, or they're limiting the buyers, where the buyers are coming from, the buyer's agents. I have a solution for dual. Give me just 1 second. I promise I will get to it. We do have a possible solution for dual. But what we're saying with dual is if I don't have both parties informed written consent, either party is saying, I don't want to work with another client in your firm. What's not allowed is undisclosed dual agency. We can't just start acting like a dual agent unless we have informed written consent of both parties. If y'all don't have that written down now, please do. Informed written consent of both parties. They have to be aware of what they're giving up. They have to be aware of what they're getting into. Part of the reason why we have time with sellers before we list the property, part of the reason why we do buyer consultations before we start showing buyers property is to, one, help explain this, help to get this point across, but two, kind of go through the process with your sellers or buyers. What happens when we get an offer? What happens when I want to make an offer? What happens when we go under contract? If we can have some of these conversations up front, then we've taken away some of that guesswork for our clients. Let's say, for example, you go under contract, your buyer client contracts with a home listed with your firm. You go under contract and your buyer client looks at you and says, should I have a home inspection? We all know the answer to that is what? Absolutely. But if I tell my buyer client that they should have a home inspection, didn't I just harm the seller client? Do sellers want buyers to have home inspections? No. The home inspector's job is to go through the property and point out everything wrong with it, right? The home inspectors are going to walk in the front door and tell you what a lovely house it is. They're going to walk in the front door and find all the problems. That's the home inspector's job. So if you tell your buyer client, have a home inspection, you've harmed your seller client, your firm's seller client. But if you can have this conversation with your buyer up front before you ever show them the first property, tell them, once we go under contract, I think you should have a home inspection. So that way, does that make sense to you guys? This is why we try to spend time with buyers and sellers before we're ever in this situation. I cannot give advocacy. I cannot give advice. What we're looking for is disclosed dual agency. It's purposely created, it's intentionally created. There's that informed written consent again. But understand, even in a dual agency situation, that still doesn't give me a free ticket to run around and blab information about the other. Usually when we talk about certain confidential information about the other party, we're referring to PTM, price, term, and motive. I may know how low the seller is willing to go on their asking price. Does that mean I tell the buyer, can I pit the two against each other? I may know the buyer's motivation for buying. Does that give me a free ticket to tell the seller? So even in dual agency, I still owe the party certain level of confidentiality. So in dual agency, let me do that. In dual agency, you have the seller on one side of the wall, you have the buyer on the other side of the wall, and then straddling the wall is the firm and all the agents. In dual agency, we're straddling the wall. I'm not on either side of the wall. I'm not standing with the seller. I'm not standing with the buyer. Dual agency is always one firm, one transaction, two clients. And again, maybe it's one agent within the same firm, maybe it's two agents, either one. Again, I do have a possible solution for dual agency. But before I do that, let me go back and get my questions. I'll answer that one in just a second, Sierra. What happens if the two parties do not agree? If they're two clients and either client says no, I can't show the property. I either can't allow you in to see it, or I have to have both parties agree. And if either party says, no, I'm not doing dual, then we can't show the property. The parties have already said, we don't want to work with another client represented by your firm. PTM was price, term, and motive. That's that certain confidential information. So is it Jose? That's not how I say your name. How would I say your name? I think you told me this before.
Josue.
Josue, okay. So what was your question?
So back to the dual agency thing, you said that you can't give any advice to either party. So say if I remember in the beginning you mentioned appraisers and counselors. Would counselors be considered something like that?
If the relationship is with the firm, right? So like when we talked about counselor in unit 1, we were helping to counsel our clients through the transaction, help give them advice. There's a joke out there that agents should have a psychology degree because we're asked for counsel, we're asked for advice on a regular basis. I had one buyer, I swear to God, you guys, every time she called me, she started every single phone call with, I know you're not my therapist, but, so that's what we meant by counseling. Again, the relationship is between the clients and who?
The firm.
The firm. So if that relationship is with the seller client and the buyer client and the firm.
So
guys, please, I'm sorry.
no, it's okay.
The example I gave earlier was a large firm that has 3 different branches throughout that, right? We're all in the same firm, right? If your firm that you're joining has more than one office location, they'll let you know. But we're all under the same umbrella as the firm. And the example I gave had 300 agents in the firm between the 3 offices. I need you to understand, though, that dual agency, all you need is one listing for the potential of dual agency. If you're a sole practitioner, you're a one-man show, and you have one listing, dual agency is a phone call away. Have you guys ever seen a for sale sign in a front yard? There's usually a phone number, a website, some way to contact me. I want you to call me about my listing. Yes, I want you to call. And especially if you're not working with an agent, now I can have. So when you call me off my sign, one of the first things I'm going to ask you is, are you working with an agent? I'm not being nosy. I just want to know. We'll talk a little bit more about that. And if you say, no, I'm not working with an agent, can you represent me if I buy this house? How I answer that depends on if buyer and seller have purposely entered into dual agency and if they allow it. So I don't want you guys to get stuck in your minds that dual agency only happens in large firms. You could be a sole practitioner with one listing, and dual agency is a phone call away. This is tough to wrap your brains around because most of you sent me your introductions. Most of you sent me your, if you haven't done that yet, there's your little reminder to do so. When you guys send me your introductions, most of you tell me you're in here, you're in this class, you want to get into real estate because you want to help people. That's what most of you tell me. You like to look at houses, you like to watch HGTV, turn it off, and you like to help people. And now here I am standing here babbling on and on and on about how there may be a case, there may be a scenario where you don't have your client's best interest. Dual agency is not in the best interest of the client. Think about what we're asking the client to do. We're telling the client, I'm not only going to serve you, I'm not only going to give you OCAR, but I'm going to share that with somebody else. And here I am telling you that there may be a case in dual agency, for example, that you don't fully represent the client. And that's where that advocacy goes away. I have to take a step back. Remember, it's my role that changes. The seller's still selling and the buyer's still buying. But it's my role that changes. The firm stops being a coach and starts being a referee. How often does dual agency happen? Every single day. Every single day. It's one phone call away. So what we're talking about now, let's just go back to your book. So I don't want to go back in PowerPoint, but let's just go back to your book, page 154. And we talked about single agency, 154 to the top of 155. We talked about single agency. Single agency says the firm represents the buyer or the seller, but never both in the same transaction. When the firm represents both in the same transaction, that's dual agency. So all firms may not practice dual agency. If they're a single agency company, only one party gets to be the client of the firm. So in dual agency, let me draw another picture. Do we like pictures? I do. If we're not in dual agency, the seller stands on one side of the wall with their agent. And the buyer stands on the other side of the wall with their agent. This is an agent. These agents work for two different firms. The seller is represented by ABC Realty. The buyer is represented by XYZ Realty. When we get into dual agency, the seller's still over here, the buyer's still over here. That didn't change, did it? They're still out there, two different teams playing the game. The role that changed is that of the firm. and all the agents within the firm. They are now straddling the wall, treating both parties fairly and equally, representing both interests, no advocacy, no advice. What other questions do we have on dual? You guys gonna come back after break? Okay, so we're gonna go ahead and take our break. When we come back, I got a possible solution to dual agency. We're not done yet, so it's a possible solution. We'll talk about that when we get back. So let's take 10. Today's a big day. Today's a big day. There's several different things we're throwing at you that it's got you scratching your head. So please remember, we just met this a couple hours ago. You guys have got to spend time on this stuff. Oh, are you guys there? You guys there? I just flickered on my end. Okay. All right. You guys have got, we all promised me right hand up. Everybody put your right hand up. Right hand up. Repeat after me. Julie, I promise I will spend time with agency. There we go. All right. Thank you. Am I jerky on your end? A little bit? I'm a little jerky on my end. Bear with me. Maybe this will work out. The internet's great, right? All right. So I'm taking attendance. So what's the possible solution to dual agency? The firm may offer something called designated dual agency. Again, please let me talk and then I'll open it up for questions. Is that fair? The firm may offer something called designated dual agency. Designated dual agency is a form of dual agency. You guys see dual agency in the name? Designated is a form of dual. We cannot do designated if the parties don't first agree to dual. So I have to have both parties agree to do dual before we can offer designated. In order for the firm to offer designated, they have to have a company policy in place about how they're going to handle it. How are they going to practice this? Designated, because it's a form of dual, because designated is a form of dual, we once again are talking about a transaction that's one firm, one transaction, two clients, designated as always, two agents. So we get permission to do dual. Guys, dual is not in the best interest of the buyer or the seller. Can we get that? I'm telling you, my advocacy is going away. You can ask me questions, but I can't answer, right? It's not in the best interest of the client, which is why we have to have informed written consent. So the picture that we're looking at, this was our dual agency picture, right? The seller's on one side of the wall, the buyer's on the other, and the firm and all of the agents are straddling the wall. If the parties agree to designated and the firm has a policy in place to be designated, the firm, the broker in charge, that's what BIC means, broker in charge. The firm designates one agent to work exclusively with the seller. They designate a different agent in the firm to work exclusively with the buyer. One agent has been kicked off the wall and is allowed to work solely with the seller. A different agent has been kicked off the wall and allowed to work exclusively with the buyer. The firm and all the other agents remain in dual. Everybody else is still straddling the wall. One agent has been designated to work exclusively with the seller. The other agent has been designated to work exclusively with the buyer, the firm remains in dual. Now, these agents can proceed with the transaction as if they were with two different firms. The firm remains the referee. One agent is allowed to be the coach of the seller, and a different agent is allowed to be the coach of the buyer. Designated is always, I got a couple caveats to designated. And again, I'm getting there in just 1 second. Let me just recap. Designated is a form of dual. We can't offer designated if they don't first agree to dual. So how do we get them to do designated? We first got, so if they say no to dual, if your firm offers designated, we can give them this little carrot, right? We can say, look, if I can get you to say yes to designated, there's a chance that the buyer will say yes to designated as well. Once the agents have been kicked off the wall, they proceed. They might as well be two different firms. They go back to being a coach. They can be the advocate. They can offer advice. Again, though, not all firms do designated. Let's go back to our sole practitioner. In order to be designated, you have to have two agents. Sole practitioners, how many agents? Just one. So can a sole practitioner practice designated dual agency? No. What if there was only 3 of us in the firm? It might be difficult for us to do it, right? Because we're such small numbers. Here's the caveats. Let me explain that a little bit further. Here are the caveats. There are 2 things about designated. In addition to having a company policy, the firm allowing it, agents cannot be designated if they have received confidential information about the other party. You cannot be designated if you already know something about the other party. So let's say I'm the broker in charge. I'm the firm. You all are affiliated with me. We're in a dual agency situation, and the clients are going, golly, I don't like that. I want you to be my advocate. I want you to be the best one for me, the best advice for me, the best advocate for me. I go to one of you in the firm, probably the one that's been working with the seller all along anyway, and I ask you, do you know anything about my buyer that can harm them in this transaction? And you say no. I designate you to work exclusively with my seller. Then I go to the agent that's been working with the buyer. And I say, do you know anything about my seller that could harm them in this transaction? If you say no, then I designate you to work with the seller. But what if you say yes? What if you say, you know, well, our kids play soccer together and we attend PTA, same Sunday school. Could it stand to reason that you might know something about my seller that could harm them in this transaction? Yeah, you may have confidential information. You cannot be designated if you have received prior confidential information about the other party. So I can't designate you. So now I go to another agent in the firm and ask them if they knew anything about my seller. No. All right, then I'm going to kick you off the law to work with my buyer. I will probably get this agent a referral fee. I'm not going to let their efforts go unnoticed. I'll get you some kind of referral fee, but I cannot allow you to work with my buyer when you know something confidential about my seller. And that's the broker in charge's responsibility, is to make sure before two agents are designated, that's the BIC's responsibility, to make sure that you don't have confidential information about the other party. Once you are designated, if you learn something about the other side, your loyalty is to who? Your loyalty is to your client. So if you learn something about my seller once you've been designated, it's your duty to tell my buyer. This only applies confidential information prior to be designated. The other caveat to designated dual agency is it's the biggest topic in this unit, problem topic in this unit. It might be the biggest problem topic in this class. The other caveat to designated dual agency, PB is provisional broker. Provisional broker is you guys once you get your license, your newbies, your brokers with training wheels. We'll talk about the provisional broker. The provisional broker affiliates with the firm. The firm takes the PB under their wing. If the broker in charge is doing their job, they're pretty much in the provisional broker's back pocket. They're involved in the transaction. They know about the PB's client. Maybe they were even there on the listing appointment or the buyer consultation appointment. Because of the relationship between the provisional broker and the broker in charge, the two cannot ever be designated opposite of each other. They can be in dual. They can be in dual together. They cannot be designated. This relationship is never allowed to be designated. Any other relationship is allowed. The PB can be designated opposite of a PB. A PB can be designated opposite of a broker, a full broker. A full broker can be designated opposite of a full broker. A broker can be designated opposite of a BIC. Any other combination is allowed as long as you don't have prior confidential information about the other side. Part of what the company's policy has, the written policy about designated, is how the BIC is going to designate and how they're storing their clients' files, how they're keeping the client's information. Today, this probably isn't as much of an issue as what it was once upon a time ago. Today, we have some kind of electronic transaction. If I were the broker in charge of our firm, Julie's Real Estate Shop, I have access to all the transactional files because they're my files. But you can only see the files you create. So if you create a file for 123 Main Street, I'm the only one that can see it. Not everybody else can see it. Once upon a time ago, before e-files, before .loop and DocuSign and zip forms and all that, files were kept in these things called file cabinets. You guys remember these? And we had the file cabinet room, which was a room full of file cabinets. And one thing that the BIC had to specify was who had access to those files, who had access to that information. Because you don't want to designate somebody and then have them come into the office in the middle of the night and flip through your files, right? So part of the company policy says, how are we going to keep the client's information protected? Again, it's a lot easier now. You need to log in and a password today, but it still could be compromised, right? Do accounts get hacked? Every day. So that's part of what the policy should say, is how we're protecting the sellers and buyers' confidential information so the agent can't use it against the opposing party. So let's talk through a scenario. Let's go back to, you all work for Julie's Real Estate Shop. And let's say we have sales meeting this morning. And we're in sales meeting and I'm talking about, upcoming events, social hour. We're going to talk about, there's a form change coming that I heard about, whatever. We're going to go through and we're going to make sure we're all on the same page. And then during sales meeting, I say, does anybody have a new listing that they'd like to share? Do you have a listing coming this week that you'd like to share? And one of you raise your hand and you say, I got a new listing coming. It's in High Point. It's a 3-bed, 2-bath. It's got a 2-car garage and it's just adorable. Did you, as another agent with the firm, learn anything that would be considered confidential information about the seller? I just talked about the property, right? I told you about the property. You can go to Zillow.com and look that up, right? You can see that it's a 3-bed, 2-bath, 2-car garage. We can talk about the property all day long. What if though? What if I'm not a good Vic and I'm not paying attention? I go over here to get me a donut and I'm not paying attention. And that agent keeps talking. 3-bed, 2-bath, 2-car garage, just adorable. The sellers are kind of in a crunch to sell. You see, they're in this situation right now where they're getting ready to enter into this nasty divorce. And if they can sell now, then they're going to get more money than if the court issues it. Did I just stand there and allow you to blab confidential information about my seller? We can talk about the property all day long. Be very careful about talking about the people, specifically the people's price, term, and motive. If that were to happen and I were to allow you to blab about the seller's motive, why they have to sell fast, why they have to sell now, that means none of you can be designated because you now learned confidential information about my seller. And I think that's one thing that the BIC can do is make sure that they're paying attention in the sales meeting, make sure that the conversation is about the property, not about the people. Because as soon as you learn confidential information about the other party, I don't care how you learn it, as soon as you learn confidential information about the other party, the possibility for designated dual agency is not an option. With designated dual agency is not eliminated. One agent is designated, a different agent is designated. The firm and the rest of the agents remain in dual. Dual and designated are for in-house transactions. One firm, one transaction, 2 clients. We get the seller's approval or not to do dual agency before we list the property. The buyer, we may not even have to discuss dual until they want to see one of your firm's listings. We'll talk about buyer agency. It can be oral at first. We have to have both parties' approval in writing no later than presenting the offer. We can show the property with a verbal agreement to do dual, but we have to have it in writing before we present the offer. Again, we'll talk more about that. It is the individual designated dual agent that will work exclusively for the principal. One agent has been kicked off the wall to work exclusively with the seller. A different agent has been kicked off the wall to work exclusively with the buyer. Once you've been designated, proceed as if you're with 2 different firms. Those agents' roles change. You go from being the coach to the referee, from the referee back to being the coach. The firm is still the referee. The firm is still in dual. Again, all firms are different. All firms are different. So that should be within their office policy, their company policy, about how they're going to practice designated dual, if they will practice designated dual. How is the BIC going to designate? Do they have a series of questions they're going to ask? For example, the commission doesn't give the firm much information on this. The firms can create their own company policy. All the commission says is that if you're going to do designated, you have to have a company policy on how you're going to do it. And as we said, you cannot be designated if you've received confidential information about the other party. And again, I don't care how you learn it. It makes no difference how you learn it. Once you receive information about the other party, you cannot be designated. The broker in charge would need to find somebody else that doesn't have confidential information before you can be designated. And I'm going to venture out and say this. Problem topic number 1 of pre-licensing in the state of North Carolina is that the BIC and the provisional broker can never be designated opposite of each other. They can be in dual. Yes to dual, no to designated. Remember, in dual, they're both acting as the referee. But because of the nature of their relationship, again, you guys, once you affiliate with your firm, if you affiliate as a provisional broker, your BIC is in your back pocket. They're with you. They're going on your listing appointments. They're going on your buyer consultation. If they're doing their job, they know something about your client. That's the nature of the relationship. Some BICs may have a company policy that they will never allow themselves to be designated. Because shouldn't the broker in charge, they may know something about everybody, right? As we said, any other combination is allowed as long as you don't have confidential information about the other party. So what I want to do real quick, before we open it up for questions, I want to go back. Everybody good? We'll come back to this in just a second. This is kind of recap of what we said previously. I'll come back to it. Let's go back to our offer to purchase and contract. And let's look at our relationships. The buyers are on the left, sellers on the right, buyers on the left. The selling firm is the one working with the buyer. And the selling firm has to list if they're acting as a buyer's agent, a seller sub-agent, or a dual agent. What is the firm's relationship? Buyer's agent, seller's agent, or dual agent. Then we have a place to mark if the individual agent has been designated. So in order for this to work, the firm has to be a dual agent and the individual has been designated. We go through this similar exercise on the right-hand side with sellers. The firm is acting as a seller's agent or a dual agent. And check only if applicable, the individual agent has been designated. The firm is the one in dual agency. The individual agent is the one to be designated. As long as they don't have prior confidential information about the other party, and it's not the PB and the BIC. Does designated make you feel a little bit better? Advocacy comes back. Once you've been designated, when your client looks at you and says, how much should I offer? I can answer that question. When your buyer looks at you and says, should I get a home inspection? I can go back to answering question. Advocacy comes back once you've been designated. The only time the clients don't have advocacy is when we're in dual. Questions? Does it happen? Designated brokers know about it? Absolutely. The BIC is having a conversation. Hey, buyer's agent, do you know anything confidential about my seller? Hey, listing agent, do you know anything confidential about my buyer? The BIC specifically designates, tells them you are going to be a designated agent. So yes, you know if you've been designated. Are you always either designated or designated is a form of dual? So if you're designated, you've said yes to dual, the firm remains in dual. It's the individual agent that's been designated. As long as we have informed written consent of both parties. And again, if we don't look at it on Thursday, then we'll get to it next Tuesday. We're going to look at our agency agreements, and we're going to see our agency agreements. They help us form the words. That's one thing I like so much about our forms. You know, back in my administrative day, I did new agent training. So I got you guys as soon as you got your license. And the number one question I had from you guys when you first started was, how do I know what to say? And I'm telling you, a lot of times the forms help you put words in your mouth. If you're familiar with the forms, it'll help you put together what you want to say to your client. So explaining dual, explaining designated can get tricky, but let the forms help you. And again, we'll look at our agency agreement forms that discuss dual and designated. We'll see those in Unit 8. We'll address that later, Nancy. We will get to that. Let's see. So when in dual, the buyer or the seller asks you for help, you can simply say, I'm sorry, due to our agreement, I cannot help. That just as a reminder. That's right. That's right. So remember, dual agency is created how? Intentionally created with informed written consent. So you tell your sellers, you tell your buyers, if we enter into dual, I can't give you advice. They say, okay, I'll do it. And now they're in dual and they're asking you for advice. Yes, remind them, guys, we talked about this. You agreed to this. That's that informed written consent. Never look at anybody and say, we're going to do dual, sign here. That's not giving informed written consent. So the BIC can choose what kind of agent they will be the whole time, or it changes. I'm not sure I understand that. What kind of agent? Dual agent or listing. So it can vary from transaction to transaction, right? I need permission to walk in the front door and show the property. I need to know that the seller is open to dual agency. Why would you show a property if a seller says, no, I'm not doing dual, right? Right, save yourself some time. So if you know the seller's open for you to walk in the door, maybe the buyer buys this house, maybe they don't. Just because you show the property doesn't mean we're going to go under contract. This is why we have to have dual agency in writing by both parties before we're presenting the offer. What happens if the designated brokers have heard about the seller and don't disclose it? So now they could face disciplinary action from the real estate commission because they act unworthy, they act incompetent, they lied, they misrepresented themselves. So if y'all didn't write that down earlier, write it down now. Don't lie. So when your BIC looks at you and says, do you know anything about my sellers? And you go, If that's a lie, you will face disciplinary action. You could be sued. You've harmed the public. So how do you avoid that? Don't lie. I wish I could stand here and tell you everybody's good, honest people. We know better though, don't we? We know people. I just want to point out, we'll come back and talk about this more, probably get to this on Thursday. 162, 163, there's some good situations. I like the situations, they give us examples. Again, this is discussing oral versus written, and we're getting ready to talk about oral. I might touch on it today, but we'll talk more about that on Thursday. But again, I just point you to various things in your book because there's good information in your book. The various in practice and for examples and situations and all that is to better help you understand. Also, you guys remember the back of your book starting on page 707. 707. We looked at this last week. You're supposed to be reading ahead, looking at 707. We're going to talk about it. Fast forward to page 716 though. 716 starts talking about our agency agreements and disclosure. It talks about dual agency. It talks about designated. We're getting ready to talk about disclosures right now. Dual 718, designated 719. So again, this is kind of reinforcing what I asked you guys to do last week, to start reading that license law and commission rule comments. Starts on page 707. We'll spend time in that section. The very last thing we do together is spend time in that section. But this is why I want you guys to start reading that section now, because it might help you now. It's another way for you guys to get dual and designated. See why I want you to look ahead? I think it's a lot easier when you expose yourself to it before we talk about it in class. The other type of agency relationship that we're just going to mention real quick, I got a whole unit dedicated to this. But another agency relationship is when the owner hires an agent to manage their rental property. That's what the property manager's job is, to manage property on behalf of the owner. Make a note that we'll see this in Unit 12. But what's important to understand right now, for the property manager, usually the landlord is your client, the tenants are your customers. Who gets old car in this situation? The owner, the landlord. The tenants get what? Honesty, fairness, and the disclosure of material facts. It's rare. Again, I hesitate to say a word like always or never. It's rare for the tenant to be represented by the property manager. Most owners say, oh no, I want you working for me and me alone. So most of the time in a rental situation, the tenant is just a customer. Again, whole unit dedicated to this. So we'll talk about this in Unit 12. I give you guys a lot to think about. Part of my responsibility is to make sure, remember that intentionally created with informed written consent. Part of my responsibility is to help educate the consumer. Let them know what that informed written consent is. And one way that I can help educate the consumer is by doing my agency disclosure. Now, before you guys start writing, please listen to me for 1 second. I'll give you plenty of time to write it down, I promise. If you have a personal experience, this is the one section I need you to put that off to the side, because most of you are going to try to come back and tell me that this isn't the way your agent did it. Your test is not going to be on your personal experience. And I'm not here to tell you if your agent was right or wrong. I'm telling you what you need to know for your test. Everybody with me? This is the biggest argument you and I have, is agency disclosure. I'm telling you what you need to know for your test. It may or may not have happened for you this way, but this is the way that it is. And I'm not about to tell you if your agent was right or wrong. Not my job, not my place. There's two sides to every story too. Y'all remember that. We have got to disclose our status to consumers. And we disclose our status to consumers by doing our working with real estate agent disclosures. Now we're going to look at it in just a second. We're going to end here today. We'll start talking about this on Thursday when we come back. So I won't get through all this today, but that's okay because that gives us a minute to think about it. The Real Estate Commission says that working with real estate agents is mandatory for all sales transactions. Is it required on lease transactions? What does that say? Do I need to give you guys a minute to write? It's not required for all lease transactions. Thus, it's not required for all real estate transactions. It's only required on what type of transactions? Sales transactions. And can we all go ahead and agree? This is a problem topic. Commercial sales is a sales transaction. So when we talk about sales, maybe I'm talking about residential, maybe I'm talking about commercial. We give and review our working with real estate agents disclosure no later than first substantial contact. And we'll talk about first substantial contact. We'll see this on Thursday. But for right now, let's just understand first substantial contact is this moment in time when the conversation switches gears from the property to the person. I can talk about the property all day long. But when the person starts sharing information with me, once again, let's take this back to our PTM. When the buyer starts telling me what their price point is, what their terms are, what their motivation for buying is. When the seller starts discussing PTM with me, price, term, or motive. At that point in time, if I haven't already done it, at that point in time, I have got to stop them from talking, because every consumer deserves to know. Every consumer has a right to know who I represent, where my loyalty is, and more importantly, that I don't owe you confidentiality if you don't hire me. And that's what we're doing with our agency disclosures. I'm letting the consumer know, be very careful what you tell me. I've been hired by the seller. What you tell me, you might as well be talking to the seller directly. Be very careful what you tell me, because I take that back to my seller. And I don't owe you confidentiality. I don't owe you nothing except for honesty and fairness, disclosure of material facts, if you choose not to hire me. This is so very important. Agency disclosure does not create agency. Agency disclosure does not create agency. What creates agency are our agency agreements. Agency disclosure is my opportunity to warn the consumer. Think of agency disclosure. You're reading the consumer their Miranda rights. Y'all seen on TV what Miranda rights say? Anything you say can be held against you. When we're doing our disclosure, we're Mirandarizing the word now. We're Mirandarizing the consumer. We're warning them, please stop talking. I know it's rude to interrupt people when they're talking. In this case, it's rude to let them talk. It's rude to let them share. Guys, people blow my mind. People will talk. Holy crow. You can meet somebody in an open house and they walk in the door and say, we're super motivated buyers and we're pre-approved for this amount. We got to buy something within the next. I don't even know your name yet, but I already know all this confidential information about your price point, your motivation. We have always got to be on alert for first substantial contact. Whenever you're acting in capacity of an agent, we've got to be on alert for first substantial contact. Again, we're getting ready to look at the disclosure, and this is actually good that we'll pick back up here on Thursday. The purpose of the disclosure is to make sure that the consumer understands, I don't owe you confidentiality. Careful what you tell me. Because what you tell me, I have a duty. OCAR says I have a duty to share that with my client. I owe it to the consumer to make them think before they tell me. Do you think most buyers would look directly at the seller and tell them how much they're willing to, how high they're willing to go? Do you think most buyers will look at the sellers and say, I know I'm offering 150, but if we negotiate, I go up to 157. Because what's the seller going to say? 157 it is, right? And they need to understand that when they tell me that, they might as well be having a conversation directly with the seller. Because the seller in that case is my client. They're the ones that I owe the duty and the responsibility to. The other purpose of our working with real estate agent disclosure is to tell the consumer, introduce the consumer to the type of agency options that my firm has available. Do we practice dual? Do we practice designated? What are the options that my firm has to offer? So we're going to go off PowerPoint just for 1 second. And if we go and learn test pass and we look at the Unit 7 material, I got some good stuff in Unit 7, but one of them includes our new working with real estate agent disclosure. We just got this last July. This thing is not a year old yet. Look in your book. You guys see pages 167 and 168. It's a get your magnifying glass, I know, but it's a smaller version of the brochure that we used to have. So last July, they updated the look of it. Now it looks like this. What's important to you guys is the only thing that changed is the look of it. The information is still the same. The rule is still the same. The law is still the same. Trust me, the disclosure you're looking at on my computer screen, it was a lot easier to get across to a consumer than what you looked at 167 and 168. If you happen to wake up on July 1st of 2021 and heard a resounding woohoo from across the state of North Carolina, that was all of us brokers celebrating this new disclosure. We're all thrilled. 169 to 172 is the information from the brochure on 167 and 168. So they did blow it up where you can actually see it, right? So you don't really need your magnifying glass. So again, the only thing that changes is how it looks. The information stays the same. So today we have this amazing disclosure. Actually, I got two disclosures today. I got one for sellers and I got one for buyers. So it depends on who you're talking to. When you first meet somebody very early in your relationship, this is for consumers. They're not a client, they're not a customer. Maybe they will become a client or a customer. Maybe I'll never ever see them again. But they have a duty to know where I stand. So it tells us that this form is required in all sales transactions, including residential and commercial. Again, does that say lease? It says sales. So it's required for all sales transactions, and it starts with this big important, and right off the bat, it says this form is not a contract. It is simply a disclosure. And when you sign this disclosure, all you're signing is that you received it. We're not creating agency. We don't owe each other anything. This is me disclosing my status to you. In a real estate sales transaction, it is important that you understand whether an agent represents you. Real estate agents are required to review this form with you at first substantial contact. In other words, before they can ask for or receive your confidential information, agents are required to give you a copy of this form. The whole point of this form is for the consumer's protection. And then we actually spell it out. Do not share any confidential information with the agent or assume that the agent is acting on your behalf until you have entered into a written agreement with the agent to represent you. Otherwise, check this out. The agent can share your confidential information with others. I don't really know another way to say that. Stop talking, warning, what you're telling me, I can take that back. This is what we're warning the consumers about. I owe you nothing. And that includes confidentiality until we enter into an agency agreement. Then there's a note to the agent. The agent checks all relationship types that may apply to the seller. The agent checks the boxes of the types of agency that their firm offers. This isn't necessarily how we are going to interact. This isn't necessarily our relationship. This is the relationships that my firm offers, the possibilities. So we could, if we check this box, the firm could offer to be your listing agent. The agent who gave you this form and their firm must enter into a written listing agreement with you before they can market your property. If you sign the listing agreement, the firm and its agents represent you. The buyer would either be represented by an agent affiliated with a different firm or be unrepresented. Does your firm do dual agency? Dual agency will occur if your listing firm has a buyer client who wants to purchase your property. If you agree in a written agency agreement, the firm and any agent of the same firm would be permitted to represent you and the buyer at the same time. Dual agents' loyalty would be divided between you and the buyer, but the firm and its agents must treat you and the buyer fairly and equally and cannot help you gain one advantage over the other party. If your firm offers designated dual agency, if you agree, your firm would represent both you and the buyer, but the firm would designate one agent to represent you and a different agent to represent the buyer. Each designated agent would be loyal only to their client. And then the firm may offer to work with an unrepresented seller. Unrepresented sellers are also known as for sale by owners, FSBOs, as we like to call them. The agent who gave you this form will not be representing you and has no loyalty to you. The agent will represent only the buyer. Do not share any confidential information with this agent. So again, I'm not telling you how we're going to work. I'm not telling you our relationship. I'm telling you what our options are. I'm checking the boxes to disclose our options, what my firm offers. There's a Q&A brochure. We'll look at that in just a second. I got a place for the sellers to sign and the individual agent to sign. And then we go through a similar exercise working with real estate if you're talking for buyers. Again, the important is the same. This isn't a contract. Don't you share confidential information with me. Our relationship options, buyer agency, dual agency, designated dual agency, or unrepresented buyer, making me the seller's subagent. The agent who gave you this form may assist you in your purchase, but will not be representing you and has no loyalty to you. The agent will represent the seller. Once again, do not share any confidential information. I think this disclosure, again, we're getting ready to look at the Q&A, but I think the disclosure, the Q&A, yes, it's meant for the public, but it helps you guys better understand it as you guys are trying to learn. And remember, you guys, one day you're going to be out there explaining this to the public. You're going to be out there meeting buyers and sellers and explaining these relationships. The other thing I want to point out, learn, test, pass. I love this. The Real Estate Commission has provided us with this Q&A brochure. It looks similar to what you're looking like in your book, but it's much more helpful. Actually, page 1 starts down here on page 2, the way it's set up. But couple things I like about this. Again, I think you guys should read this. I think you guys should look at this because it explains agency to the buyers and sellers, and it helps you guys understand it better. So we go through just some basics. You know, what does the word agency mean? What is an agency agreement? Do not share confidential information. Then there's a Q&A for sellers. So if you're working specifically with sellers, if you're talking to sellers, the Q&A brochure puts words in your mouth. It helps you explain when you're talking to sellers. Then there's a Q&A section for buyers. When you're working with buyers, how can you help explain this to buyers? What happens when our agency agreement is over? To print it, to terminate it. Can you print it? Yep, sure can. You can purchase the brochure and have a nice little glossy. If you're frugal like me, you can do a flat PDF. When you're in Learn, Test, Pass, you can download it and save it or print it. It's going to be small on regular paper. It's designed for like really long paper. My favorite part about our new Q&A brochure, we just got in July of 2021. They gave us pictures. I like pictures. Pictures help us explain the different types of agency. So in one scenario, we have a buyer agent and a seller agent. You see the buyer's got a necklace on, the seller has a scarf on, indicating they're two different people. You see broker A is red, broker B is blue. That's indicating there were two different firms. So in this scenario, broker A is with one firm working with the buyer. Broker B is with a different firm working with the seller. This is a cooperative, a co-op situation. Two firms are cooperating together to help the buyer and seller. Dual agency. How many firms? Just one. I only got one color of agent, right? I just got a red agent, indicating that it's one firm. So dual agency, you see now they're holding hands, seeing they're holding hands, isn't that cute? So dual agency, one agent can be working with both the buyer and the seller, or in dual agency, two agents of the same firm, you see they're the same color, one working with the buyer, one working with the seller. Look at them, they're holding hands. Why? Because they're the same firm. What happens when we go to designated? Still the same firm, but now they're not holding hands anymore. Don't you just love the pictures? This made my year last year when they released this. So I think this brochure is great for you guys to help you learn. I think the pictures help. This is in Learn, Test, Pass. It's under the Unit 7 material. This is our Q&A brochure. Again, you're welcome to print it out, but you're going to have bigger paper. You can't do it with 8.5 by 11 and be able to read it. This information, back to your book, page 169 through 172. Again, that's verbiage from the previous brochure, but that information is the same. So I think the several different ways you can expose yourself to it, the better it's going to be. When we come back together on Thursday, I got a little bit more to say about agency disclosure. So this will be good because we can kind of recap what we just talked about, and then we can expand, talk a little bit more about agency disclosure. And then we're about wrapped up. We'll talk about your relationship with your firm as an independent contractor. And then in Unit 8, we start getting into specifically working with sellers, specifically working with buyers, and we'll look at our agency agreements. So that's what we're going to do on Thursday. Finish Unit 7, get started on Unit 8. We won't get through Unit 8 on Thursday, but I ask that you still please look ahead. I do think it helps if you guys see this stuff before class. Fair enough? Thumbs up? Cool, thank you. I like that. Y'all have a good afternoon. Have a good day tomorrow. Study hard. Let me know if I can help. And I will see everybody first thing Thursday morning, starting at 9 sharp.